that we have the hereditary basis. Now she is dismissed by appeal, madam.
Yes, Tuesday.
Petition, my lord.
Yes.
In respect of serial number 42 is concerned,
Wait,
my lord.
Mr. Page wise will come. Wait, Mr. Madam, we'll call by page wise.
Page number 1, serial number 2. Page number 2, serial number 3 to 8. Page number 3, serial number 9 and 10. Page number 4, serial number 11 and 12. Page number 5, serial number 13 to 15. Page number 6, serial number 16 to 18. Page number 7, serial number 19 to 22. Page number 8, serial number 23 to 27.
My lord, one submission. My lord, submission.
Yes.
Serial number
Yes.
26, my lord.
Yes.
Review petition.
Yes.
My lord, for steps for R1, R1 is the wife and R2 is the husband. Husband is represented by N. Gopal Krishna. Even for R1 also, my lord, he is appearing for the claimant only. Both are wife and husband. His name may be shown. There is no necessity to take steps for R1.
Yes, let the matter is called, Mr. Then I have to pass an order. Yes.
Please.
Number 9, serial number 28 to 31.
I appeal for the petitions, my lord. Serial number 28. There is public petitions.
Serial number
28.
58, Learned Counsel for the appellant press 2 weeks time. Yes. 29.
Yes.
Here for 28 filing in appeal, IFR. Yes. Yes, Mr. What do you want? Why you want time? No, this is only for condonation of delay. Next week. The request of counsel for that respondent. Use this matter next week. Yes.
Page number 10, serial number 32 to 37.
You are appearing for? Yes, at the request of counsel for the appellant. Use this matter of 2 weeks.
Page number 11, serial number 38 to 45.
Serial number 39.
Yes.
For the respondent. There is a part heard matter here. By and before the division bench. Mainly pay for a week's time.
That you are appearing for?
Respondent.
Have you informed other side?
Just inform audience.
Yes, you have no objection.
Two owners have been escaped from delegating the property. They were directed to.
Then he has an objection.
No, it's not regarding the property, very common area.
No, I'm not hearing that matter. Yes, sir. He is objecting that. If he no objection, I can grant the time. Yes, Mr.
There one part heard matter is Swami. Either is held up. That is the
Not
reason.
that not tomorrow. Not Monday. Yes. At the request of counsel for respondent K-Waiter, leave this matter on Monday. Yes.
My lord,
Very good.
but it's 42, serial number 42.
Yes.
I pray for week's accommodation. I am not feeling well, my lord.
You are appearing for?
I am appearing for respondent Jagdish P, my lord, because earlier it comes for thrice before the court, my lord. The appellant counsel is not appearing. Kindly have time tomorrow or day after tomorrow. The matter,
The request of counsel. Have you informed other side?
please, I will inform him. Please, my lord.
No. Not. I am asking that. Have you informed? Before that, you have to inform, Mr. Yes, at the request of counsel for the respondent. It is matter next week. Yes, what is that?
41.
You are appearing for?
Appellant.
Yes, at the request of counsel for the appellant. Leave this matter up to 2 weeks.
Page number 12, serial number 46 to 52.
My lord, serial number 52, my lord. I'm appearing for
Yes.
respondents. My lord, some
Yes.
inconvenience, my lord. Kindly have this matter next week. I have informed the other side also.
Yes, at the request of respondent. Leave this matter up to 2 weeks.
Page number 30, serial number 53 to 55.
If for. Yes. Yes, at the request of counsel for the appellant. Leave this matter up to 2 weeks.
Bid number 1 for being spoken to, serial number 1, case is Sudarshan for appellant, Dhananjaya N.
Yes, where is KC Sudarshan?
Manoj, I am here, Manoj. I am online.
Yes, Mr. Yeah, Mr. Only the one sole respondent is dead. You are not brought the notice of the court.
I am
The
the
application has been filed, Manoj. Application has been filed on 9th of January, Manoj.
No, before bringing that LS, how can you get an interim order? It is against the dead person.
Manoj, at that time I didn't have a notice, my lord. If
No,
your
that
lordship,
they have filed on that day. There is a memo.
Manoj, I have not been served. Manoj, I have not been
even-
served.
No, Mr. Sudarshan, cost list has been showing that there is a memo for reporting the death.
Correct, my lord. I agree, my lord. I agree. There's no answer on that.
Then should you not brought to the notice of the court?
My lord, it was never the intention, my lord. It was never the intention. My lord, I have not been
I will
served.
recall that. I will
My lord,
recall
lordship may
that
not
order.
recall
Yes.
it. I already filed an application. Subsequently, I have filed an application, my lord. I
No,
was
that
not aware of that
only
on that
after
day.
they have been implemented, then the interim order has to be passed. Otherwise, it is against the dead person, Mr.
My lord,
Yes.
I appreciate, my lord. I has already been filed, my lord.
Yes, we will consider that.
Kindly consider that, my lord.
Yes.
my lord, serial number 47, my lord.
As on the day order has been passed, 5/1/2023. Contesting respondent has died. It is reported that contesting respondent is dead. LS has not yet been brought on record. Therefore, order dated 5/1/2023 is recalled. Post this matter on Monday.
My lord, not on Monday, my lord. Lordship will have on Thursday.
First, yes.
Thursday, my lord. Oblige.
My lord,
5/1/2023 order is recalled.
Order serial number 2, case Chandranatha Riga for appellant, yes, Rajshekar.
Withdrawn. Yes, Learned Counsel for the appellant has filed a memo. Leave of this court to withdraw this appeal. The appeal is dismissed as withdrawn. Yes, Learned Counsel for the appellant has submitted. Needful has been done. Office to verify and proceed further.
So I complied with all the office objections and I also filed a memo. I request your lordship to kindly look into the memo.
What is that office objection?
And number one, office objection number one is that the schedule stated in the appeal memo, as per the plaint, the schedule details in the plaint and IA filed before the trial court differ. Whereas the IA is one and the order 33 is one.
Schedule stated in that petitioner miscellaneous petition is not tallying with the plaint.
Yes, ma'am. That is correct. Because that is not 33(1), where under the sue as prime of corporation. And the assets of the petitioner will have to be stated in two schedules, one movable and another immovable. And the plain is different, where under the schedule with regard to the relief sought for will be asked. That is why it differs. That is what I have stated, and I have even filed a copy of the miscellaneous petition, not 33. And
Better copy of the appeal memo to be filed since too many corrections. Yes, you made lot of corrections in that. You file in a better appeal memo.
Yes.
Yes.
Office objections may be overruled and.
That is what that office objection, Mr. You have to comply that.
Office objection. The other objections.
Other objection, you comply that, then we'll overrule them. Yes. Amended plaint to be produced to verify cost title. Plaint has been amended. Why?
There has been,
Where is that your plaint?
the plaint is annexed to along with then 53, 56 your lordship, along with that there is
What is that amendment they have sought? There is no any amendment to the plain. I'm asking, is there any amendment to the plain? That you have to answer. Yes. Then you furnish that better copy of that appeal. Then we'll consider other ones. Yes, in both. Yes, week's time is granted to comply that obstacle.
Number 6, Chetan Jadhav for appellant, Ajay Govindrat.
The appellant should pray for a week's time to comply with office objections.
Yes, week's time is granted to comply.
We will give you.
Yes,
They pay
let
for a
him
week's.
comply that obstacle. Yes,
Pay for a week's.
week's time is granted to comply that obstacle. Yes, what?
It's a trademark.
Yes,
Last occasion, what your lordship indicated for?
2:30. 2:30. Otherwise, we will be struck in this matter. I can't go for.
We also want up the traffic.
Yes, yes. 10K of appeal against the order passed.
Lordship, I'm appearing for serial number 9.
8.
Sorry, sir.
None appear. Last occasion also, none appear for that appellant. At the last chance, release this matter on 8th.
Serial number 9, Ravi Raghavan for appellant, Bhargav D. Bhatt.
Lordship, I'm appearing.
Yes, Mr.
Lordship, last occasion, the court had issued emergent notice to all the respondents. To some of the respondent, the notices could not be served, and to some of the respondent, the notices were served, but none appeared.
Yes, you take fresh steps in respect of that notice which has not been served. Yes,
Lordship,
2 weeks.
I tried to serve on the addresses which I have available with me. I may not be in the knowledge of the updated address of the respondent if they have changed their address.
That is your duty, Mr. It is due person who has approached the court has to be see that others has to be served. It is not the duty of the court. Yes, you have to search their address and this thing. 2 weeks time is granted to do the needful.
2 weeks time, Lordship.
Yes.
Can it be 4 weeks, Lordship? Because I may find it difficult to get their addresses.
Yes.
Connected matter, SP Bhagwan.
For eviction, my lord. Since more than 30 years, they have not paid any rent, my lord, and they are enjoying the status quo order. In Article 1164 of 19, my lord. Connected matter to judgment. 2 appeals are there to judgment.
No, who is appearing for HN Baswaraj? What is that first RFA?
First RFA is, there are 2 dependents, number 2, 3. The second dependent has filed, it is with one of the tenant. He has filed, first RFA is 15.
Why 2 dependent? How many tenants are
There
there?
are 2 premises. Suit is filed.
2 premises.
Because first dependent is the tenant, he has subleased the property to 2 people. That is dependent number 2 and 3. Dependent number 2 has filed the 1528 of 2019. Third dependent has filed 1164 of 2019. The suit is decreed, madam.
No, you are the landlord.
And the landlord.
Now, who is your tenant?
Well, D1 was my tenant. He has subleased the property to D2 and D3.
Nagendra is your tenant.
Yes.
Then Nagendra has filed an appeal here.
No, he's no one. This legal representative is brought on record.
They have filed an appeal.
They have not filed any appeal, madam. They have subleased the property. The sublessee has filed the appeal.
Who is sublessee?
Sublessee is third dependent.
Third dependent.
Yes. Bangalore tailoring hall.
Then in which case they are not paying that
In
rent?
both of them are not paying any rent.
Yes, Mr. Who is appearing for HN Basuraj? Yes, you are appearing for whom, Mr. Yes, you are not paying the rent. What is that interim order? Is there any interim order here? Mr.?
But yes, but in 1164, there is maintenance status.
You file an application for vacating. You will vacate it. Either they will pay it or
No, madam.
We are ready to pay the rent.
how much rent is due?
2004, 20 years, they're not paid anything. The amount's almost 11,40,000. Not even a paisa is paid.
What they were agreed.
What is the degree?
The amount is the agreement.
Is there any, wait, is there any degree for payment of?
Yes, 5,000 every month.
Handed over the vacant possession of future property within 4 months from the date of this order, failing which liberty to take steps in accordance with so far as the damage and condition of the same to be determined in separate inquiry. Article 20 will be accordingly.
5,000 from the date of suit.
5,000 per month, when that would be the case. What is that interim order past year?
It is just maintain status quo, madam, because they are expressed in 2019 matter of the state and expressed threat of eviction. So it is,
You file an vacating application.
yes, madam.
We'll consider that.
Yes, madam.
Yes.
I have next week, it's a date.
You file it, Mr. You, the court has to say you have to file, it is your duty. Yes. Yes, in interim order in both the cases.
No, only in one case.
First matter only, week's time is granted to do the needful. Second matter only, 10.1 only, interim order granted earlier is extended till next date of it.
Well, what's up? The first matter, my name is not shown, but I quite recall that just 2 days back. I directed
Which
to
respondent?
first respondent. I'm the landowner.
No, Anil Kumar has filed an caveat. What is your name?
My name is Mithun. I've taken NOC for me.
Now you have, yes.
Yes.
What is that, SK Mithun
Yes, Ken.
has submitted that he has filed an wakalat for R1 office to verify and show his name in that basket. Yes.
Number 11, Prasanna Kumar PS for appellant.
Yes.
Address left at the office ಬಂದಿದೆ.
Yes.
Kindly reissue the notice.
Yes, week's time is granted.
Much.
Pay the process to issue notice to respondent number 2.
Number 12, Chukka Reddy for appellant, SG Suresh, A. Rao.
Yes.
In the subject that respondent number 4 and 5 died.
Hmm.
And we have filed the memo. Yes, and filed the LR's application also.
It's not posted. LR application ಹಾಕಿದಾರಂತೆ.
February 25, 2022, filed LR's application and report of the death, respondent 4 and 5.
Put up ಮಾಡೋದಿಲ್ಲ ನಾವು.
ಹೌದು. Yeah.
This Mr. Stuff in the cash shown in that affidavit in support of the applicant, delay in filing the application, LR records is concerned, abated, set aside. LR's IN number ಎಷ್ಟು ಇದು?
3 of 21, 1, 2, 3 of.
Allow ಆಗಿದೆ ಅಲ್ರಿ, what is this?
Cause register the report again. 518 to see the LR's.
Application is allowed, you have to amend it.
Put this IMA the notice. 518 to see. 518 to see.
Okay. It is not brought to the notice of the court that without notice it has been allowed now.
The application in the office.
He filed an IA for recalling that order. Mr. It's already an order by this court, by other bench. Sorry, appellant ಇರೋದಿದ್ದಾರೆ ಅಂತ ಮಾಡಿ. In the cash shown in the affidavit, support of application delay in bringing LR's, that means such as LR's. The appellant is dead. No.
Appellant is dead, but the appellant already LR's already on record. Here you see.
Which is that IA you have filed for bringing LR's of the appellant? 1, 2, 3 here you bring LR's from you.
February, August 19, 21 we filed application.
Wait, Mr. LRs of the appellant. That is LRs of the appellant, Mr. Which is the IA you have filed for respondent?
Respondent number 4 and 5.
There is no such IA, Mr.
On February, 25 February of filed.
There is no such IA here.
And death report on that day, you have filed.
Yes, Cabinet Council for the appellant has submitted that. Appellant has filed an IA for bringing LRs of deceased
4 and 5.
4 and 5. After to verify and put up.
And we have to take steps to.
Milord, may
Yes.
I,
In
Milord,
the meantime, week's time is granted to pay the process to issue notice to R9.
9.
Yes.
I am for the respondent.
Yes.
Filed applications for bringing the legal heirs on record.
Yes.
Milord,
Who is
that
that?
is secondary.
Plaintiff
That is
first
secondary.
respondent.
That is secondary. I will file Vakala those LRs. Let
Passed
it
away.
be title.
His
Milord,
LRs are to be brought on record.
kindly have a look at order dated 8/6/2022.
Wait, Mr. I will hear you. Wait. I'm not passing any order. Awaiting service of notice to 2 to 5 and 13. Steps to be taken for since unserved cover, vacating interim order, non-filing of the paper book, 20 days in filing an LR's application. LR of whom? The respondent number 1.
Yes.
Then he is appearing for?
He is appearing for respondent number 6 and respondent number 12.
Yes. What is that interim order? He
8/6/2022.
filed an application.
Alienated, must not be alienated.
Who is he? Milord,
8/6/2022.
let me be heard for a moment. I had entered caveat.
Yes.
It was served on him. Without disclosing that, he gets an interim order against me. He is nobody to my property. By a fraudulent method, he had entered into a JDA with one Paul Fernandez. 20 years now, my lord, because of the appellant, we have been denied user of our 3 acres of property in HPR layout.
Yes.
Let him take steps leisurely, let him file papers book laterally, let the interim order be vacated.
After hearing only. Yes.
Allah, how
Yes,
he could
what is the
obtain
yes,
interim
what is
order without disclosing to the court that there is a caveat. Whereas Purvankara has filed, they served a copy on me
Yes.
and told the court. This
Yes.
gentleman prefers not to
Yes.
serve a copy on me and to obtain an interim order.
Yes. Yes. What is the suit for?
And I had filed a suit for declaration.
Yes.
One Paul Fernandez came forward
Yes.
to develop our property. There
Yes.
were 3 senior citizens. They entered into joint development agreement. He
Yes.
could not do it. Clandestinely, this appellant enters into another joint development agreement with that Paul
Yes.
Fernandez,
Yes.
not with the landowners.
Yes.
Coming to know that, I filed OS seeking declaration for cancellation of the JD
Yes.
and GPS. My suit
Yes.
is decreed after contest for 17 long years.
Yes.
Paul Fernandez did not appear, whereas the appellant before my lords appeared, except
Yes.
dragging on, he did not even file written statement. No evidence was let in.
Yes.
He had approached this on court seeking for arbitration. This on
Yes.
court directed him to produce the alleged GPA which he had submitted. He could not produce.
Yes.
Ultimately, he got dismissed that JA.
Yes.
Now, he wants an injunction order against the true owners of the land. He was happy to have dragged on the matter for 17 long years. He
Yes.
has no defense. He has not even filed 2 lines of written statement. He did not step into witness box. What right he has to seek for injunction order against the true owners of the land? And unfair conduct is
not serving the appeal memo. If my
Yes.
submission had been taken, interim order would not have been considered by the Honorable Court.
Yes.
He has not even disclosed that he did not even file statement in the suit.
Yes, Mr.
Just make a submission.
Yeah.
But, a learned friend appears for the 6th and 12th respondents.
I will represent
16.
every one of the landlords. I will
6th
file.
and 12th, my lord, defendants before the trial court.
Hmm.
My lord, suit is filed by one Captain G. Ramananda Reddy.
Hmm.
My lord, there is no decree in favor of the 6th and 12th defendants. Please have a look at what the judgment and decree. My lord, they are defendants. They did not raise any counter claim. And my lord, they are
No,
executed.
that's one suit is filed by
Yes, my lord.
that Purvankar Project Limited.
Yes,
What is that suit
My
filed
lord,
by?
that is another suit, my lord, which they have filed for, my lord, enforcement of, my lord, an MOU.
Yes.
That has been dismissed, my lord. The present appeal, my lord, arises out of OS number 3721 of 2005.
Where is that degree?
My lord, page number
Common-
125, page number 125, my lord, will get the, my lord, decree.
Where is that plaintiff? Who has filed that? Who
My
are
lord,
the-
the decree is there, please see, my lord, page number 125. My lord, 1G Ramananda Reddy, my lord, files the suit.
Yes.
My lord, this suit is, my lord, decree, against which, my lord, the present appeal is filed.
Yes.
My learned friend,
What is that degree has been passed? Declare that?
my lord, declaring that, my lord, the power of attorney, my lord, executed in favor of, my lord, the second defendant is, my lord, null and void. And joint development agreement dated 1/3/2005, which is, my lord, a registered document, executed in my favor, is also null and void.
Now, who are these defendants?
My lord, my lord kindly takes the cost title.
Yes.
My lord, the plaintiff,
Yes.
the 6th defendant and the 12th defendant, my lord, all execute a joint development agreement
Yes.
in favor of the second, my lord, defendant,
6 defendant and
12th defendant.
12 defendant.
All, my lord, children of Gurappa Reddy.
Yes.
They execute, my lord, a joint development agreement
Hmm.
in favor of, my lord, the second defendant.
Yes.
My lord, possession is delivered in favor of the second defendant.
Yes.
My lord, the objective is to, my lord, develop the property into, my lord, apartments, office spaces, and shopping and commercial complex.
Yes.
The second defendant, my lord, for some reason is unable to develop.
Yes.
Therefore, my lord, as an assignee, my lord, he assigns all his rights in favor of the 4th defendant,
Yes.
whom I represent, my lord.
Yes.
There is a registered, my lord,
That is true. Then what is that right of that plaintiff?
but plaintiff has executed a joint development agreement. His right is to get constructed area
No, he has entered in a joint development agreement with whom?
with the second defendant. my lord.
Second defendant.
Yes, my lord.
What about that 6th and
They have
12th,
also entered into a joint development agreement.
along with that plaintiff?
Yes, yes, my lord. They do not challenge it. That is the submission I'm making.
Yes.
They do not file a suit.
Yes.
Suit is filed only by one person.
Yes.
So therefore, my lord, the 6th defendant and the 12th defendant,
Yes.
who are executants of the joint development agreement, they
Yes.
don't come forward and file a suit.
Yes.
They don't raise any counter claim.
Yes.
Suit is filed only by one executant of the joint development agreement.
Yes.
That is, my lord, Ramananda Reddy, who is now no more.
Yes.
Now, the decree that is passed is also in favor of the plaintiff. No decree is passed in favor of defendant number 6 and 12.
Yes.
Please have a look at, my lord, the operative portion, page 89.
Yes.
Suit filed by the plaintiff in OS number 3721 is decreed with cost. Page number, my lord, 119. 119, my lord, is the operative portion.
Yes.
Suit of the plaintiff is decreed, my lord, with cost. General power of attorney executed by the plaintiff, 6th defendant, Gurappa Reddy, in favor of the second defendant, having not seen the light of the day, is hereby declared as cancelled. The same is also not
No,
binding.
executed by plaintiff,
Yes, my lord.
6th defendant,
Yes, my lord, and Gurappa Reddy.
Gurappa Reddy in favor of the defendant. and having
Number
not
2.
been- Yes.
Yes. Now, very importantly, my lord, there is a registered joint development agreement.
Yes.
My lord, exhibit P43, which is dated 31st of March 1998. My lord, no declaration is sought in relation to the said document.
Yes.
my lord, in favor of the second defendant,
Yes.
my lord, there is a registered joint development agreement. There is a power of attorney that is executed. In relation to the power of attorney, they seek a declaration. But in relation to the registered joint development agreement, which is an admitted document in favor of the second defendant, no declaration is sought. That document is not challenged. But since the second defendant is unable to develop, he, my lord, assigns that right in favor of the fourth defendant. I represent the fourth defendant. Fourth defendant is the appellant before my lords.
Yes.
So therefore, in relation to the joint development agreement dated 31/3/1998, which is produced as Exhibit P43.
Now, what is that cancelled by decree? What is that cancellation? Declared that cancelled, same is not binding.
That they are
GPA.
executed one GPA, my lord.
See,
Right.
GPA has been cancelled.
Yes, my lord.
On the basis of the GPA only, that joint development agreement has been executed.
In my favor, yes, my lord.
Then how it will be sustained, Mr. GPA is gone.
GPA has gone, but
Yes.
under the, my lord, I am only an assignee. My lord,
No.
if we-
See, even then,
yes, my lord.
person whose favor
Yes,
that GPA is there,
yes,
GPA has been cancelled.
cancelled. Now,
He
whether
has
this,
no right to assign to you.
no, my lord, this is cancelled now. It is not cancelled earlier.
Yes, yes.
So therefore, before cancellation, my lord, the assignment has been made in my favor. Whether this cancellation is valid or not has to be decided by this
That
court.
is true.
Yes, my lord.
That now we have challenging that.
Yes,
But you are saying that still that by joint development agreement is existing.
no,
That
joint
cannot be.
development agreement is dated 31/3/1998.
No,
that is-
no,
that-
that is on the basis of the GPA.
No, 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 no. That is executed by the owners directly in favor of the second defendant. Their possession is delivered to the second defendant.
But second defendant has not assigned that right to you
Yes, he has assigned that right to me.
in spite of that this thing.
Yes, my lord. That is the case. That has to be
Then-
decided.
No.
Please see, my lord, para 13 of the appeal memorandum I have extracted.
This sort of misleading should be stopped. But
No, I can't hear you properly, mister. There is a disturbance from your side.
Lords, there were
Please, I should not make the petition.
father, son, and brother-in-law executed a joint development agreement for the second defendant to develop the property. He did
Yes.
not do it for the 15 years of time. He had no
Yes.
authority. Once if I give a property for development to X, X cannot assign it to somebody. A peculiar strategy is
Yes.
adopted. Such a plea was not even put forward in writing before the trial court. He did not even enter the witness.
Just request, my lord, have a look at the synopsis. Synopsis,
Yes.
my lord, has the entire sequence of events.
But
If my
even
lord kindly says synopsis at page 1.
Yes.
what is it?
14
I don't know. He did not explain to the court why he did not even serve the copy of the memo and IA on me in spite of service of caveat. There has to be
Yes.
some fairness. And he represents such a party who does not even file return statement or enter witness box.
Yes.
How can he
Please have a look at
prevent from dealing their own land, even after lapse of 17 years of litigation, my lord?
Yes.
He
Lord,
has power of attorney. My lord,
Yes.
I should not be saying that. It is before His Lordship Justice Shantan Gowda. He directed
Yes.
him to produce the GPA. He took time, twice. Then ultimately he said he does not have GPA.
land is alienated, my lord, which is the subject matter of the joint development. Nothing will survive, my lord, to be decided in the appeal.
No,
The alienation is
No,
prevented.
that
let him produce the GPA.
Mr. BC Sitaram Rao, your voice is not clear. I can't hear anything from your side. That is the problem.
My lord, will kindly have tomorrow. I will come to the court and
Yes. Tomorrow.
Tomorrow, but Monday.
Monday.
my lord, he does
Yes,
not
yes.
do.
Tomorrow. Yes.
Well,
No, he requested Monday. If you are agreed or Monday, otherwise tomorrow. Interim order granted earlier is extended till next date appeal.
Tomorrow only ಏನಾಗತ್ತೆ ನಾವೇನು ನಾಳೆ ಹೋಗಿ ಸೇಲ್ ಡೀಡ್ ಬರ್ಕೊಡಲ್ಲ ಜಾಯಿಂಟ್ ಡೆವಲಪ್ಮೆಂಟ್ ಮಾಡಲ್ಲ.
ಆಯ್ತು. Yes, that is for me to decide. Yes, tomorrow till tomorrow. Yes. Yes. Learned counsel for the appellant has filed a memo. Of this court to withdraw this appeal. Is taken on record. The above appeal is dismissed as withdrawn. Yes. Week's time is granted to do the needful.
60, everything that has to be for appellate.
2 weeks time is granted to do the needful.
Interim order.
What is this, Mr. MFA Krab, who is appearing for Prasanna Via? Why they have connected without notice? Who has asked to connect it, Mr.?
Objection was connected. May RTA may not have to take steps may not in respect of several respondents.
No, that just connected, no notice has been issued. We will issue notice also. In
Yes.
the meantime, the process will be completed.
Yes, ma'am.
Yes, in that you are taking notice to which respondent, Mr.
Process. I am the defendant number LR D1A2 and D.
What is that name of
Sushila, Soumya, Srisha and Mahesha.
Sushila, Soumya?
Srisha and Mahesha.
Yes, you will take notice 1 to 4.
Yes, ma'am.
Yes. Shri Ravi Shankar Shastri is directed to take notice for respondent number 1 to 4. The appellant in RFA CROB is directed to serve 2 sets of copies on Ravi Shankar Shastri Ji. Issue notice to respondent number 5 to 33.
In my appeal, my interim order may kindly be extended.
Yes, our MFA RFA first materally week's time is granted to do the needful. Interim order granted earlier is extended till next date of it.
Please.
Respond number 1 to 4 plots are the appellants in the connected. Respond number 8 to 33 plots are the purchaser. Even not saving with the present cause objections. Identical claim lots. Therefore, notice may not be necessary for those respondents filing new. Because they have not done it and they have served in the connected appeal.
That is different. That is different. But in your appeal, you want to dispense.
Yes, because I am not claiming any relief against them.
1 to 4, Ravi Shankar is directed to take notice. Which respondent from?
8 to 33.
Only 8 to 33. There is no other respondent.
No other respondents, 5 to 7.
5 to 7.
Yes.
Issue notice to 5 to 7. 8 to 30.
33.
33. Learned counsel for the appellant cross objector. Yes. Appellant in cross objector RFA CROB has filed a memo seeking dispensation of notice to respondent number 8 to 33. Memo is taken on record. Notice to respondent number 8 to 33 is dispensed at the risk of that cross objector.
Kumar for appellant.
The counsel for the appellant has filed a memo seeking leave of this court to withdraw this appeal. Memo is taken on record. The above appeal is dismissed as withdrawn. Yes.
Similarity for appellant.
The counsel for the appellant has filed a memo dated 20th/4/2022 for this court to withdraw this appeal. The memo is taken on record. The above appeal is dismissed.
Not validating in steps for R1. Technically, we provided again requesting for this court to direct the office for the preparation of the paperwork ballot and the undertaking that will also be the cost for it in terms of Rule 15.
Yes.
So the reason is that DCR has already been called for in the matter and the.
Now they have to evaluate that price. What is the cost?
Yes.
That Council for Appellant has filed an IA 1 of 2023 permission for preparation of the paper book from the registry, and is ready to deposit that cost of paper book. The registry is direct, IA is allowed. The registry is directed to prepare the paper book after collecting the cost of the paper book from the appellant. Yes. What is that other respondent?
R1 taken steps. R2 will not be within a week's time. I'll pay PF for that.
Yes, week's time is granted to do the needful in respect of payment of process.
Number 20, we shall not for appellant.
On rectification of the details of the different. Yes, Mr. What?
Two.
Non-reflecting of the details of the dependent number 2 or the cost title, OS, judgment and degree.
What has happened is they are from the same family. In the OS itself, it has been mentioned 2A, 2B, 2C. There is no 2 at all. They are from the same family.
I agree. 2A, 2B, and 3 are. Is there a LRs or an?
No, they are not the LRs. They are the defendants 2, 3, and 4.
2A, 2B, 2C and the act madidra. Where is that provision to make it?
Before the trial court, they have done
it. Whether they are family members, they are relatives, they have to be made in a different dependent unless there is an LR. Is it not? Where is that degree?
It is page 94.
2A, 2B, 2C and there.
Page 47.
I think office objection is there.
Reflection
Reflection details of the dependent at the cost of class judgment and along with the council submission of the office note. That is the only office objection.
The second set of other appeals are filed before the bench. It's already admitted. In the second set of filed, there is one of the objection. You have filed second set.
Then act division bench gogilla.
Is valuation now after the admission posted.
Another suit is what that?
What has happened is there are 7 suits filed by the plaintiff against the purchaser and his brothers.
Different persons.
Different persons. So the common judgment.
What is the valuation here? 14 lakhs 50. Yes. Submission of learned council. Council of learned council for submission of learned council for the appellant is accepted. Office objection is overruled. Yes. What is this matter, Mr.?
A suit for declaration and possession was filed. The first defendant is a purchaser of the property. Defendant 2, 3, and 4, who is my brother, brother's wife, and son, have sold the property to them based on.
What is that degree? What has happened to that suit? Why?
The khata for the individual name is not shown in the flat sheet. What at the time of joint development agreement, the khata is in my name. That has been produced. But here, what I say is that each flat, the khata has not been produced. Joint development agreement is there. The joint development developer also says that these flats go my share. But the trial court individual
already khata suit for partition.
Partition suit for partition. Suit partition again.
And what is the suit for?
That my brother has sold these properties, the flats to the.
What is the relief you have sought in the suit?
Executed by my brother and his wife and son.
Plaintiff had sued defendant for an directing defendant to the suit for possession. Only possession. Alternative to direct the defendant to jointly severally to pay the market value. Yes, your suit for possession has been dismissed. Yes,
792/22.
You take out notices. Issue or admit. 4 weeks time is granted to file in a paper.
Number 21, Rajeshwar opinion for appellant.
Non-arriving of a defendant number 5. What is this?
wrongly shown. I have corrected the applicant numbers. I have shown the cost item. Applicant number 4 ends with wrongly showing the client as master agent. He was a minor minutes, he was represented from natural guardian.
Master Ajay. He is a minor, yes. Represented by his natural guardian. Now, what you have shown in that appeal memo?
In the appeal number, his name is Supreet. It was wrongly shown. The oversight is not corrected.
That has to be get it corrected, Mr. Madam. Otherwise, it is not telling. Master Ajay, how can he become a that? What is the name?
Supreet.
Here is the respondent number 4. He is a defendant.
Number 4.
Why you have not objected when it is served and noticed on you? It is not your name. Then why you have not asked
Because
that? Have they not read that plain copy? They don't know what is the plain copy is. Then your name is wrongly shown, you have accepted it. No, it is not telling you. Yes. What is that other objection? Non-arriving of a defendant number 5. Arriving of an appellant number 4 is not a party before that. Yes. Submission of learned counsel for the appellant is accepted. Office objection is overruled. Yes. What is this matter?
Appellant number 1, he got information that is
Yes.
and take steps to do this.
Yes. Office objection is overruled. Yes. In the meantime, you do it. Yeah. Wait. What is that order you have to challenge? Is filed against the count of LAC. Yes. Current counsel for the client has filed a memo. Conversion of this regular first appeal into miscellaneous first appeal. The memo is taken on record. The registry is directed to convert it regular first appeal into the miscellaneous first appeal. For set 6 purpose, appeal is dismissed. Now it will be converted as an MFA. Yes. Then we can consider.
52, 1 of S for appellant.
The appeal is in view of 96 Karnataka Civil Service, not exceeding. Yes, last time. From the valuation the appellant subject matter of appeal is valid. Recovery of money of 2 lakhs. It has raised an objection. None appear for the appellant. Office has raised an objection regarding the maintainability and the ground that appeal is valid does not exceeding rupees 10 lakhs. Hence, in view of the above, the appeal filed before this court is not maintainable. The registry is directed to return that appeal papers to that appellant to represent the same before appropriate legal forum. Office is directed to return that certified copies of the judgment and degree to that appellant. 4 weeks time is granted to represent the same before that appropriate court from the date of receipt of certified copies from this court. For statistics purpose, the appeal is disposed of.
Number 24. Andhra.
Complaints of the office objection for second time.
Objections are left out. One is 50 and the second one is relationship certificate.
There are 8 office objections. Yes. 2 weeks time is granted. 2 weeks, you comply 2 days itself, no problem. Maximum, it should not be posted again for compliance. That's why.
No, because the objections are left out and during this the day I will complain.
Yes, weeks time is granted to comply that officer. Section 96 of CPC. Yes, Mr. Badrinath.
I appeal for the appellant. Weeks,
Yes, Mr.
weeks time may be granted. I'll
No, how can you maintain RFA, Mr.?
I'll explain. I have to lay on the research work. I'll make.
No, not that, Mr. You have to file an MFA, not RFA. It is an order passed under that execution petition, filed application under that. That is an MFA. RFA is only against the degree.
Yes,
Is it not?
I'll agree. 1 week's time, I'll make it my submissions.
What submission? That is the only. Is there any other law that? Yes. Only you have to file an application for this thing.
Otherwise, I'll file a memo for conversion and next week I'll be filing.
Yes.
Next week.
Next time at the request of counsel for the appellant. All this matter next week.
Number 26, Vijay Kumar for petitioner, N. Gopalakrishna. Number 26.
Yes, Mr. Vijay Kumar.
Serial number 26, D. Vijay Kumar.
Yes, week's time is granted to do the needful.
Application matter, serial number 27, K. M. Ravi Kumar, H. Ramachandra for appellant at S3 Exile.
Number 22, my lord.
Yes, why it is dismissed, Mr.? The matter has called twice. There is no representation of this. As petition from the time of the day none appears, it was ordered to take necessary steps in respect of the deceased or free. Within which matter was listed on the day. There was no representation. Yes, we have not. We are not on that. When the matter is called so many times, you are not represented and taken a step. No, that why you have accepted that brief, such a brief, Mister, when it is committed by that other side. Yes, see that the reason for dismissal. What is the suit for? LAC matter.
All these 7 members are
Yes, we'll recall subject to payment of costs. Otherwise, this is how that, Mister. 2013 matter. See, when the matter is listed on 21/20, on that day none appears. Appellant was ordered to take necessary steps in respect of deceased R3. R3 is dead. We have not taken any steps. That have you get ready with that application to bring LRs of R3? No, Mr. Counsel, it is your appeal. You say that I don't know who is the R3, then who has to answer, Mister? You get ready with that application, then only I consider imposing the cost for recalling that application next week. Yes. Otherwise, if I recall, again, you will not take steps. Again, yes, you get ready with that office objection, then we'll see whether it can be recalled or not.
Number 28, 29 adjourned, number 30, error case note of an appellant, but
Yes, Mister.
There is a video injunction not there because the appellant was not a party to the suit proceeding. Yeah. Cooperative bank loans. The second respondent, who is the defendant, sole defendant before the trial court, he had mortgaged this property.
Suit for
Specific performance.
yes.
Filed by plaintiff against the defendant, that is the respondent number 1 has filed the suit against respondent number 2.
Yes.
But this respondent number 2.
Who is this appellant?
Appellant is a cooperative bank.
Yes.
Respondent number 2 had mortgaged this very property with the appellant bank.
Yes.
The charge of for rupees 70 lakhs is created with the appellant bank.
Yes.
Now, my lords, conveniently, the defendant enters into an agreement with the plaintiff. And the plaintiff collusively files the suit for specific performance.
Yes.
Your lordship will see the defendant has not even contested the suit.
Yes.
And this ends in a compromise, it ends in a decree.
Yes.
But I interest is secured by way of mortgage. They have obtained these decrees only to defeat the interest of the appellant bank. If either the plaintiff or the defendant are able to make good the charge which is created in the bank,
Yes.
then I will have more say. 70 lakhs is the charge. They are also clear it.
No, that you can file an appeal without any leave of the court. Application is considered. Permission to yes, yes, yes. What you said, Mister? If it is
First objection to the maintainability of the appeal is that as your lordship suit for specific performance, it can only the parties to the contract can be made as parties.
Yes.
He is not a privy to the contract. You have to say he cannot maintain the appeal. Number 2, his claim is that there is a mortgage in respect of property. Suit performance first respondent in respect of portion of the property, ground floor of the property, which is agreed to be sold by the second respondent. It is a registered agreement.
no, that is no. Before that, if it is they have created a mortgage in
It was entered in 2011. It's a registered agreement.
yes,
The specific date of the agreement is 11/7/2011.
yes,
Clear. Prior to that, there was a mortgage that has been accepted in the agreement also.
What
One
is
of the conditions in the agreement is that should clear this mortgage amount by taking the further by taking the balance amount and registered the sale. he has not done it within the time. That is that has been filed. That should take be decreed and the CLD is
Cannot
also
be degraded. That is the condition in that agreement.
even if there is a condition, his right as a mortgagee continues to subsist despite the decree. His interest, once a mortgage, always a mortgage, is the principal. His
No, even then that ownership is also transferred. The right against no, mortgage will not. Yes.
mortgage is right also. That is a very he cannot take it. In addition to that, they now see the fraudulent act that has been paid. Even the mortgage, first mortgage was done on 6th August 2010.
Yes.
Second mortgage was done on 16th December 2010. First mortgage is in the for a sum of 16 lakh. Second mortgage is 10 lakhs. Totally 25 lakhs rupees. That we are aware of it. One of the terms of the I produced that document also. Mortgage document is also produced. My agreement is 11/7/2011. Thereafter, what they have done is, I filed a suit in voice number 2437 of 2014. My agreement is also produced.
No, that you are in a cooperative society. If that charge has been created under the property, you take an action under the Cooperative Societies Act. Attachment. No, that will not nothing to do with that property.
One more thing.
Yes. What is the law on that point?
Despite this, I understand what the agreement is there. That is, despite that, subsequently in 2013, they advanced some more loan. Income certificate is also mentioned. And again,
No, subsequent events, if they do it, they will suffer.
they will subject.
In respect of that, in respect of that mortgage which is executed before that agreement of sale,
Yes.
what is the
Liability, they will have to say. Show me that what is the liability. If the liability I will have to clear it, I will clear it. That is something different.
No, one thing, Mr. Bhatt. If you are ready to clear that liability, we'll see one thing. If he is ready to dodge.
Yes.
If you are not ready to clear, then we'll go to that. What is the law on that point and all?
Yes.
First,
I'm ready to
what is
clear
that liability for? Let him answer.
As on that day.
As on
the date of this.
As on the date of the suit. Yes.
No, not as on the date of
Agreement. What is the due?
Yes.
That is.
What is balance?
Yes, all that we give that. Yes, that is the only I think they want their money back.
Yes, I want their
No, if you pay that their money, then this appeal will go. Then degree will be with you. That's all. That. Yes. When will you come back with that? Yes, that is. Yes, in respect of this property, what is the due is there? Yes, sir. They have to satisfy this code.
Yes.
Section 56 of the DPR deals with this situation.
That we'll see that if he is ready to pay, then you want that money, then that unnecessary, why you want to go on this time? Yes, when do you want? Today on 15th. 15th. Yes, use this matter on 15th.
There's an interim order.
Interim order granted earlier is extended till next date of hearing. Alla, yen not to alienate it. Alla, yen, what is that? Any of the interim order there from so many days, let it be continued. Now Yes. See, that is, if they are not ready, then we'll go for an, what is the law on that point? Yes.
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 Declaration and permanent injunction have been discussed by the trial court on 26/9/2022. And because of the
Suit for,
declaration and permanent injunction.
what is that bringing LRs of deceased?
The plaintiff number 3 passed away on 14/7/2022, my lord.
Now that he's
Only legal area is appellant number 7. Wants to come on that.
no, the plaintiff is an appellant, is it not? Which appellant is that, Mr.?
Plaintiff number 3 was before the trial court. The trial court itself, plaintiff number 3 passed away. In that place, only appellant number 7 wants to implead herself in that place.
That appellant number 3 is dead.
Plaintiff number 7 stepped into the shoes of plaintiff number 3.
Stepped into suit. I will come later, Mr. Who has dead? Appellant number 3 is dead.
Plaintiff number 3 before the trial court. Before the judgment only, she passed away.
I three plaintiff number 3 ಇಲ್ಲಿ ಯಾವುದು ಇಲ್ಲಿ
ಇಲ್ಲ ಸತ್ತೋಗಿದ್ದಾರೆ. ಅದರಿಂದ ನಾವು
ಯಾರು ಮಾಡಿದಿರಾ ಇಲ್ಲಿ?
ಅದರಿಂದ ನಾವು appellant number 7 ನ ಮಾಡಿದ್ವಿ.
Appellant number
7.
What is that?
ಆರ್ ಶಿಲ್ಪಾ.
Shilpa.
ಎಲ್ಲ ನಮ್ಮ plaintiff number 3 ಸೋಲ್
Three. Who is 3? Mangala Gauri. Mangala Gauri is dead.
During the pendency of the suit, only she passed away.
Have you filed an application?
Three applications I have filed with questionable for to bring the alerts of
Mangala Gauri and records. Yes.
2 days delay.
Yes. Yeah. Of 2022 is filed for bringing LRs of deceased plaintiff number 3 for the reason stated in the accompanying affidavit. IA2 of 2022 is allowed, and consequently IA3 of 2022 abatement is allowed, and IA2 of 2022 is allowed. LRs of deceased plaintiff number 3 is appellant number 7 is permitted to prosecute the case. Appeal. Yes.
Facts of the case.
Accordingly, IA 3 and 2 and 3 as disposed of. Yes, issue notice. Huh? No. There is a delay, Mr. Therefore, I issued notice without going to that merit of the case. We'll see and delay.
Serial number 30, admission matter, serial number 32, adjourn, serial number 33, MR limited for appellant, Kumar MN.
Yes, Mr.
It's a railway. Tribunal has rejected their claim saying that there was no failure to pay. That he is a
Yes, Mr. Yes, 33.
This case. Page number 13. Certificate is recovered. The tribunal dismissed the claim petition of the appellant on the ground that there was no eyewitness to the incident.
FIR was registered, inquest conducted, the body of the person deceased. Have they filed that report, that DMR or some report?
Yes, my lord. DRM report also filed.
What they said?
As DRM report is page number 22, my lord.
Is there case that you are traveling on that train that they have not disputed?
Well, journey ticket is admitted. Journey ticket is recovered from the body of the
Mere
deceased.
recovery of the ticket would not sufficient to prove that incident has occurred while deceased was traveling the train. That's a question. What is that charge sheet?
Charge sheet is saying that the incident occurred only when falling from the train.
Yes, Mr.
They never challenged the same. And
Police
never
record
disproved
says-
the ticket, my lord.
Yes, we'll admit it and post for hearing. Yes. Or admit.
Same journey ticket.
Hard admit.
Prasad.
Yes. Yes, sir.
Blanket order is granted. And purchase of the property in 1 crore 80 lakhs. But the contention is that they are entered into an agreement of sale in 6/1/2008 and subsequently. I'm only asking, modify it, permit me to construct.
No, that the suit for
Suit for specifics for farm.
suit is decreed.
No, IA one blanket injunction put there against me, not to alienate, not to encumber, not to construct also. I'm a bona fide purchaser after.
No, Lord, wait, mister. Let me understand that why you, before finishing that, first I have to understand the case. Then only I can understand what is your argument. See,
I have purchased this property after giving a paper publication on 9/4, on 10/5, I purchased it for 1 crore 80 lakhs.
yes,
Their contention is that they had entered into an agreement of sale in the year 2018,
now, who is
2015.
the vendor? Dependent number one.
One dependents, 1 to 1 and 2, 1A, 1B, 1C, 1.
Yes, dependent number 1 to 3 has executed an agreement in their favor.
Sale in their favor. in the year
Then what is the
2015.
2009?
Yeah, yeah, agreement 2009.
2009. When you have purchased that property?
6/1. Yeah. They entered into the agreement. Kempachari and Magan Naga is the defendants. Kempachari was supposed to have been allotted a site by the BDA, site number 1705 in Kengeri, Upanagra. The allotment of sale did not put in. The case of the plaintiff is that he helped the children in getting the sale deed from the BDA respect of this site or any other alternative site. So 2 agreements he enters into, one on 6/1/2009 to purchase 1705
Yes.
or any other alternative site. He claimed
Now that, suppose if he succeed in the suit.
if he succeeds in the suit, it's a different thing. But I cannot be being purchased it for 1 crore. I will not claim equities. I want to put up my residence. I want to live there. I will not claim equities. Or he should have been put on terms. 50 lakhs bank guarantee put lay. That if he loses, 1 crore.
That will put it. If he loses, he has to give a damages. Or if he agreed, you can put up a construction. If you succeed, you have to remove everything and give a vacant position. Yes, that is the only thing in that. Either he has to give the security if you lose it, or that you have to give an undertaking that if you should not create third party interest, but you go on with that construction. But if you succeed, if he wants to, that house has to be remain as it is, you can give it without claiming any equity. Or if he wants to remove and give it a vacant site. Yes, yes, that's Tuesday. Yes.
36, Ashwin Pasha for appellate. Number 36.
Yes, what is this? Yes, madam. Shilpa Shah?
Yes, my lord. Yes, my lord.
Yes.
My lord,
What,
I
this is
appear for
civil
the
matter?
appellant, my lord. It's a, my lord, identical matter, my lord. That arbitral award has been
you should
modified
notice.
in section 34 petition, my lord.
Yes, they ask right for.
I'm obliged.
Should notice, stay at right. Yes,
Karnataka for appellate.
yes, yes.
Nothing with my is more or less the settlement being discussed.
Yes.
Work out the modality. Otherwise,
As
of
far
course, we
you
can go
both,
ahead.
yes. Yes, when do you want?
2 weeks.
2 weeks. Yes, at the request of the parties, call this matter of 2 weeks.
38, Harish, next week for appellate. E. Ramesh.
Yes.
Last occasion, they have served me a copies of the documents.
Hmm.
Lords, I have verified it.
Hmm.
Lords, there are some other documents which shows that he has no title over the property, and the person who is claiming a right over this property has filed a suit against the very same parties and
Yes.
obtained a decree. Lords, and also there is a finding that she has played a fraud, grabbing the properties which are vacant. Lords, in this, it's a suit for bare intention.
Lord's injunction should, the application has been dismissed
Yes.
by considering the document. Lord's, I produced those documents and the relevant the proceeding. Let's have this matter on Tuesday Wednesday.
Yes. Witness.
The submission is that fraud and all.
No. See,
I have seen the
no,
records.
Mister, unless I ask the parties to give an facts, whatever the
Yes,
council
ma'am.
says, I understood that it is only for adjournment. I will not hear anything. And then I want, no. See, if I want to take any decision, I will ask the parties to give any details.
Yes, madam.
Therefore, whatever you said that, I have not taken that as my this thing. It will be taken when that matter has been taken for hearing.
Actually, they have. no-
Therefore, there should not be any.
That's I substantiate how the rights are there.
There should not be any submission across the bar.
And for the appellant, of course, and for the appellant, but I have produced the records to show that they have no right at all. Anyway, if you want to. Sir, it is not also.
Therefore, I am saying that when matter is going to adjourn, I will not take into that whatever that your arguments has been.
Yes, ma'am.
Don't think that whenever I am taking the matter for hearing, on that day I will take whatever, then I will take any decision. Otherwise, whatever you submitting that, nothing.
Respondent is seeking time.
Yes, that's what that now, you want time, yes.
Tuesday.
Wednesday. Yes, for request of counsel for the respondent, raise this matter on Wednesday. On that day, you make any submission. Whatever. Yes.
Date of events, the transactions.
See, if you are ready now itself, I can hear. When you are want to take an adjournment, don't go for further arguments because I will not hear anything at all. Because it is unnecessary. Again, Wednesday, I want to ask the parties to give any details because I can't remember whatever argued today. Therefore, yes.
Number 40, Narayana Patyam for appellant.
Yes. Yes, Mr. Bhatt, what do you say? Yes.
So that there to be a settlement.
Yes.
A lot of parties were directed to explore the settlement.
Yes.
My lord, I have made a proposal.
Yes.
And my lord, this is the proposal. Can we see, my lord, the MFA paper book?
Yes.
My lord, last may kindly turn to page 34.
Before that, just give me brief facts.
My lord, this is with respect to trademark and infringement of trademark.
Yes.
There is a blanket order of injunction by the court bill.
No, you are in a defendant.
I was the defendant.
Defendant there.
Yes.
What is that injunction order has been granted?
My lord,
Not to use that. Not to use that. Yes.
Has been ordered to be advertised by the registering authority.
Yes. What is your trademark?
My lord, your lordship may kindly see.
Dairy Foods, sir.
Yes. Swami, page 34. Notice.
Page 34.
Page 30.
Yes.
My lord, the left hand side, my lord, is my device mark.
Yes.
There are two things, my lord. Device mark and word mark.
Yes.
Device
Now
mark
that
is-
dispute is only a device mark.
Now the injunction is blanket.
Yes, both.
Both.
Yes.
First is Nandu Swami.
Device mark, I don't think any similarity.
Oh. Here next page, your lordship may kindly see.
This is word.
Word. Pool diary and a diary date.
Yes.
Diary, my lord, is a generic term. Something like a hotel.
Yes.
Hotel, restaurant. Other nobody can have, my lord, a propriety.
Yes.
Nandu pool diary. My lord, it is ascending. My lord,
Yes. Now understood that basic this thing. Now what is that settlement you both are?
my lord, now you have to the memo filed by me.
Yes.
My lord, I have changed the entire color. The earlier dispute, my lord, also the major part there is blue.
Yes.
Which is resembling his blue.
Yes.
Now, my lord, in the first thing I have said full diary, below is, my lord, a red color.
Yes.
Then another logo, my lord, which I intend to use this full diary.
Now,
My lord, with the coffee color.
coffee color.
And below, my lord, is the blue.
Yes.
My lord, your lordship may kindly see his logo. It is on the last page, my lord, of the MFA paper. page 39. On the right hand side, my lord, is diary date.
39, huh?
Oh, 39.
Yes, diary day.
Diary date. ಈಗ ಇದಕ್ಕೂ ಯಾವ ರಿಸೆಂಬ್ಲೆನ್ಸ್ ಇಲ್ಲ.
But
My lord, on the major part of the device, he has put blue, I have put golden and coffee color is another thing.
no, device shape is also different.
Device shape also is different. My lord,
Yes, mister, it can be made it for temporary. It is not that permanent.
Cannot be. That's all these are
No, no. I'm not saying that. I'm not deciding that main matter. Now it is for interim. Threshold. Yes. Only thing is that he can say that till the disposal of the suit, he can be permitted to use this trademark for his marketing.
He's continuing to use them. It is not that we are pressing upon content on the.
Yes.
There is no such restrictive action taken.
Then I will grant interim order.
I have.
No, otherwise it is hanging sword. Anytime you can file in a contempt.
they have already filed it. There is an interim order, so they have stopped precipitative action.
Then he would have to. Submit all the products.
My lord friend, my lord is new to this. My lord is chamber senior colleague. My lord, we had
Who is your
Mr. Yes. My
What
lord,
is-
we
what
had
is your-
2 rounds of discussion. My lord, in principle, he said he has no objection, but my lord is plainly objecting with respect to letter D, the newly produced
letter?
letter D.
D is yes.
My lord, D, there is no resemblance. My lord, mine is
Ultimately, that common man is only on the basis of the color.
color. Color, my lord, is different. One
No,
is gold and
anyhow,
other is
that
coffee color.
this is not a permanent solution. It is only a temporary
It
thing.
is only a temporary solution, and my lord, we have to get it registered before the registering authority, where my lord, he has to contest. Then just one second. Then my lord, I had said I have about 40 lakhs of packing material, which my lord mutually he also agreed that in 2 months I should liquidate that. And my lord, then is display. I have about 400 outlets. That I said in 2 months, my lord, I will have to change the logo because my lord, it is odd visual. And
Yes,
my
yes.
lord, it
Yes,
takes
yes, that is
time.
the important.
Yes, 2 months, 2 to 3 months, my lord, I will replace.
Then it is settling that entire suit itself.
Entire suit itself, my lord. One should not be up in arms, my lord, respect on this.
Yes, you contact consult your colleague. When you
Let the matter be like, so parties also can come to some consensus.
consensus, if you make an giant this thing memo, we'll consider and dispose of the suit itself.
Please, please.
Yes, that's when do you want? 2 weeks.
2 weeks.
Yes, at the request of the parties. It is matter. 2 weeks. The interim order granted earlier is extended till next date of hearing.
Some date your lordship may.
If you want date
Lord, today is
on 21st. 21st. No interim order
no,
granted.
there is an interim order not to take precipitative action.
I will see that order sheet.
My lord, your lordship may see my learned friends, colleague, my lord, took an undertaking that has been extended.
That is what the interim order. I am not getting any. That undertaking will be proceeded. Both submitted that will disclose possibilities of settlement. Seeks time to file an objection when the applicant consider. Undertake, he will not proceed the matter as interim order granted on 13/12/2022 is extended till next date of hearing.
21st of February.
21st February.
Please.
Call this matter.
My lord, this of 21st, my lord, your lordship have to 23rd.
Yes, 23rd.
41, 42 urgent, in number 43, Hari Krishna is my appellant, Joseph Anthony.
Yes.
The respondent before lordship not filed the suit for the company that is called Purvam Karar Projects Limited.
Yes.
they're in the business of real estate.
Yes.
Now, they've been using the word Purva as part of their project names. They built several buildings in Bangalore. We're all aware of it. The trademark registration law, this real estate development comes under class number 37.
Yes.
Not so far as we are concerned.
Yes.
We are not into real estate. We are making steel tubes,
Yes.
which are used partly in construction, partly elsewhere. The owner of this company, the proprietor of this company, his surname is Purva. So, my lord, in 2010,
Yes.
they registered the name as Purva. And the company is carrying on business. And the appellants also, my lord, applied for registration of the mark P and Purva both. Our marks are registered. The other side also, my lord, makes an application. Some of them are registered, some are pending. The main point that arises for consideration is this, my lord.
Yes.
I am using the name Purva
Yes.
for my company and as part of it to the products,
Yes.
which have nothing to do with real estate. Now, the learned judge, my lord, has not accepted that contention and has said that there is some passing off and an infringement. Not infringement. If I use my mark, it can't be infringement. They have to take down the mark. There's a procedure for that. That is not yet done. It's an objection. It is still pending. So, Lord, after the judgment was delivered, my lord, we requested the court to stay the operation. Honorable Court, my lord, has passed an order staying the operation till the appeal period is over.
No, you have any benefit of interim order during the
No, what happened, my lord, was there was an ad interim order granted by the trial court against me.
Yes.
On an application made by me, my lord, that application, my lord, was allowed by the was dismissed by the lower court. When the matter came up in MFA law, this honorable court, my lord, heard the matter and directed the continuation of that injunction till the suit is disposed of. So during that interregnum law, the date of the MFA order law is 27/5/22. The date of the judgment is 15/11/22.
Yes.
So in this interregnum, there was an order operating against me. But my submission, my lord, is this. Ultimately, your lordships will have to entertain this appeal, my lord, examine it. You know, there's a direct decision of the Supreme Court in the Nandini case.
Yes.
Nandini Deluxe case. The
Yes.
point that arose there was, Nandini, my lord, is the famous brand, my lord, in Karnataka, which makes all this milk and milk products. Somebody in Delhi, my lord, wanted to use a different mark with Nandini only, but for a different product. So we tried, my lord, to justify.
The product is a different.
Product is different.
Name may be somewhere similar, but product is a different.
That's the point on which Honorable Supreme Court, my lord, laid down that even if you have the registration for some category of products, if the other side is making some other product, which is a different class altogether in the trademark list,
yes,
then that mark will not apply. Of course, that arose not in passing off action, but in the registration action.
Yes.
But ultimately, my lord, that's the law declared. Therefore, my submission is, after all, my lord, I am not claiming that I am part of Purva. I don't use Purvankara, and I am not in real estate business. So if I sell my products, not making it clear that I have nothing to do with Purvankara, not my customers, a large number of customers all over the country, not buy my products. Nobody thinks, not this is a specialized industry. Not. If I'm building a house, I'll not go to the bazaar and then give me this Purva brand.
Yes.
I will
When you have
ask
registered that, when you have registered.
the registration start place in D1/8/2017, trademark number 3611130.
Yes.
Copy is produced also.
When he has registered his.
His marks, Lord, one of the first registrations were D20. What they did was in 2014, they made an application, and that application they didn't pursue, it got abandoned. So the first application they made in 2014, which they did not pursue.
Yes.
The second application, Lord, which they made was 26/3/14. In class 19, without controversy, my lord, I can submit that there is no application in class 6.
Yes.
The second application they filed was 26/3/2014.
Yes.
In class number 19.
Yes.
One more application they filed on 17/3/15, in which they say they are a proposed user in class 6. So till 2015,
yes,
they didn't even make a claim.
No, your application is under class 6.
Yes.
Yes.
Now, not another submission is admitted position. The court notes that from 2010, I've been in the business. Our company has been functioning. I'm selling the product. And also there is some evidence to show that this plaintiff, that is respondent, also had dealings with me. They bought some of my material also. So they were aware of this from 2010.
Yes.
And they filed a case, my lord,
Yes.
in 2017. So, my lord, my submission is that subject to any directions that your lordships may give, let me continue my business. Otherwise, my running business will have to stop.
Yes,
I have no other brand.
Yes, we'll hear that matter finally.
Yes, I'm ready. Any days of my limits in for the final hearing. Actually, there are two or three issues which I just wanted. Firstly, they do not have a registration when the suit was filed. In fact, the learned judge in the interim judgment itself records at page 81 in the which is at page 21 running paragraph at 53. Your lordship says
in page 53.
In page, yes. Therefore, both these certificates are from about the top about 7-8 lines.
Yes.
Therefore, both these certificates of trademark of the defendant namely are registered in the class 6 subsequent to the filing of this suit.
Yes.
The suit, the present suit was filed as on 18/7/2017. So,
No,
therefore,
if there is a trademark for any different classes,
yes, but I'll
it will also amounts to imprisonment.
Yes, it will be not because there is a specific provision under the trademark under section 29 subclause 4 of the trademark.
Yes.
It says even if the goods are dissimilar, but there are three occasions, there are three things that can arise in the trademark issue. One, where the goods are identical. The second is where the goods are similar, and the third where the goods are dissimilar, completely different goods, pencils or tractors.
But names are similar, then
But the names are identical. If I am able to prove that their adoption is that, but then an injunction came, right? That is section 29(4) if you want to see that. So therefore, there is no quarrel on the legal proposition as such.
yes.
The second aspect that in our case, I would respectfully submit that the rules are not different as my London City had put it, because at the end of the day, the pipe is going to be used only in construction, and I'm in construction industry. People who know me will obviously be inclined to buy the product of the defendant because they know me very well, and their products are used in the construction industry. That is what the learned civil judges held, the judges held in the interim judgment, and I have given judgments in this effect. So these are factual issues. That aside, there are two other aspects which I wanted to point out. One, the injunction that my learned CDA had pointed out in the MFA, it was not only from 27/5/2022, but since the date of the MFA, which was filed in the year 2018 itself. The injunction which I did not have was only in the period where the trial judge refused my injunction application till I filed the appeal. When the injunction was vacated, I had a benefit of an ex parte injunction. When it was vacated, I came to this court by way of an MFA. Ex parte injunction was granted. We filed an application.
How many days that when from which date to which date?
It was about a month and a half. I'll give the exact dates.
Yes. Till the disposal of the suit.
Yes. Yes.
Till the disposal of the MFA.
The appeal, original injunction was granted. They filed an application to vacate it. Did not pursue. Ultimately,
no, that they are in that business from 2010.
But that I see.
No. See, I'm not hearing on that.
I appreciate
said
that.
let it be continue. Then we'll ask them to file that all that paper books. Then we'll fix the date and.
But till then, there cannot be a stay only for business. In fact, they have been in country. I have moved a contempt in CC 634 of 2022, which is pending before the Honorable Chief. They have been in contempt. But therefore, merely asking for a stay when they have not been obeying the orders of this Honorable Court.
Which order they have violated?
But even in the MFA, there was an injunction as against. They continue to violate the injunction throughout. And I have thereafter moved the contempt, and the contempt is pending before this Honorable. Therefore, he who seeks equity should come to the court with clean hands, even as well as
Yes, what has happened? What has happened to the contempt? Now that
the
notice
contempt is pending.
notice
Yes,
is
they entered appearance. They had sought time as on 14/10/2022.
Yes.
And thereafter, the matter is not taken.
yes,
In
Mr.
fact, they wanted to say that they'll file a compliance affidavit, but even as on date, the contempt continues is brief.
You see, not contempt is a different issue, not which we deal with it. But what happened was, in the MFA, there was an ex parte order not granted on 12/6/18. That order expired. Thereafter, Lord, they did not get that order renewed.
Yes.
For 3 years, there was no order in the MFA.
Yes.
After the ex parte interim order expired. Then the matter was heard finally on 27/5/22.
Yes.
And by that order, the learned judge reinstated that order. That order continued to operate till judgment.
Now that they have filed a contempt that you have violated during the period of the interim 2018 to
What I'm saying is
that there was no
Yes.
interim order.
that is one. Second, Lord.
No, is it true? Interim order is not extended from
No,
2000.
the fact remains, what happened was they were at one point of time when they mentioned the matter and took time. It is apparent that he did not ignore the court that there was an interim order. And we at the
No,
next
but
year,
almost 3 years.
next year, in fact, and we're not in the subject matter here, what we have said, because the order has been vacated, it is deemed to continue. That is a position which I don't have to attend your notes. There are enough Supreme Court judgments that says, unless and until the interim order granted is specifically vacated, it is deemed to be.
No, even then it is granted for a specific period. I don't think so. Otherwise, we need not extend every time. You give me that law on that point, then I can save my time for signing that paper every.
But what has actually happened is that when they moved in application to vacate the interim order, apparently there was an interim order. Otherwise, there was no need for them to vacate it. And once they moved in application to vacate it, they did not inform me, one day they took time. And that is when the interim order was not extended. Anyway, look, that is a matter which we will argue in the contempt as we read it senior advocate. But the fact remains, there are now, your lordship also saw one factual situation that in the interim, not just this, which I showed in.
No, anyhow that you are not operating from last to so many years.
No, not so many years, only last few months. That's why I gave the dates. Kindly turn in my appeal memo to page 5, Lord. I give the list of dates.
Yes. Now, when the suit is filed,
The suit 2017, July 2017.
22/7/2017. Is there any ex parte order?
Yes. Yes, there was an ex parte order on 24/7/17.
24/7/17.
17.
Yes.
That ex parte, the IA for injunction was dismissed on 27/4/18.
18. Yes.
MFA, my lord,
Yes.
was filed 4/3/13 of 18. An ex parte order
4/3/13 of
18. An ex parte addendum order was passed on 12/6/18.
Yes.
Then, Lord, we entered appearance.
Yes.
And filed an application for vacating the interim order. Your lordship will get it in page 5 of my appeal memo.
Yes.
Second date, Lord. 3/7/18.
Yes.
3/38/18. Order passed in MFA, wherein ex parte order passed on 3/7 was not extended.
Yes.
The following order was passed.
Yes.
List the matter next week at the request of counsel for response. So from 18 till next date, 1/4/22.
Yes.
There was no order.
Yes.
Then on 27/5/22, the matter was heard and final order was made.
Yes.
So from 2018 onwards,
Yes.
firstly, not for some period when the lower court vacated the injunction, there was no order.
Yes.
Then during the pendency of the MFA law for several years, there was no order.
Yes.
Ultimately, not if I succeed in the case, my market will be completely.
Now, from 2018.
Yes.
There is no restriction against that applying. Only 1/4/2022 till the disposal of that suit.
That is their case, I get to differ.
Yes.
Subject to.
Yes. What you say about this?
That is what.
Now that I am only on the consideration of interim prior, see,
Yes.
only thing is that from 2018 he is operating. Why can't you continue for another 4 weeks?
But the difficulty is this, there should be some restrictions. Because what they have done was, even after I filed this, the lordship saw that they had filed one application. But thereafter, they have got, they filed trademark applications after trademark applications.
No, that is on merit. Yes.
The reason which I'm urging this proposition before my lords, if they are not restricted in any manner, that my entire suit, if you wait that I have had since 2017, would be of no value at all. So therefore, let them not press.
No, that is not the final. They have a right of appeal. They have come before this.
That is all the request that I am making. Let them not file any fresh application. Let them not give a fresh trademark application. And let them not make any fresh advertisements. Because these advertisements, if your lordship even goes just outside in the city of Bangalore, there are so many
you continue
advertisements
with your
in the
market without any advertisement.
May
For
make
one
the
year.
submission.
Yes.
Kindly not consider this. We are in a business scenario. But they are a big developer. I don't claim to be part of their group. I've got my own clientele, my own business. They are also used to deal with me also. I'm not the prayer which is making that I should not make any further application for registration. It's like tying me in every way. Supposing I file an application, it's not going to be heard ex parte. It's going to be advertised. They're going to have full objection. They can find. There are already 4 marks.
No, that means to say that if it is not even similar to you, also you can't file any objection.
It's not. I don't have
Only
any.
for this mark, my lord, there's a serious contest. The contest is this: the word Purva is not their only name. Their name is Purvankara. So the law is fairly well settled that when the mark I am using as Purva, this is Purvankara. So the distinction between the two is sufficient for people to be warned.
No, that has to be decided now. That
Correct. That's why I'm submitting, Lord. So for that reason, I'm submitting, Lord. When so many years have gone by, with
now that he has a benefit of decree.
Lord, the question is this, Lord. This decree, Lord, if the lordship permit me to cite one paragraph in Nandini case, the matter is covered in my favor completely.
It is that. Have they not cited this before?
Yes, cited, my lord. Cited and distinguished. Yes, cited, but not distinguished correctly. Page, Lord. The portion I rely upon is at page 64, in page 64. Another T. In para 29, my lord, the lordships refer to an earlier case in national suing case.
Yes.
Para, if I may read from the middle of that quotation.
Yes.
Moreover, in deciding whether a particular trademark is likely to deceive or cause confusion, that duty is not discharged by arriving at the mere result by merely comparing it with a trademark which is already registered and whose proprietor is offering opposition to the registration of the mark. The real question to decide in such cases is to see as to how a purchaser, who must be looked upon as an average man of ordinary intelligence, would react to a particular trademark, what association he would form by looking at the trademark, and in what respect he would connect the trademark with the goods which he would be purchasing. Lord, if I can just pause and before I read the next sentence.
Yes.
I'm a flat purchaser. I see the advertisement of Purvankara projects. I will go and see the project. And I will buy if I want to buy. I am building a house or some construction. I am a contractor. I want to buy some steel material. I will not go to Purvankara projects to buy steel material. I will go to a shop, a hardware shop. In the hardware shop, let's say, show me all your material. You show me 1, 2, 3, 4 brands. One of the brands is Purva. How will anybody associate the word Purva in a hardware shop to a real estate developer? That's the question. Then will not please see para 30.
Yes.
Applying the aforesaid principles to the instant case, when we find that not only the visual appearance of the two marks is different, they even relate to different products. Further, the manner in which they are traded by the appellant and the respondent respectively highlighted above, it is difficult to imagine that an average man of ordinary intelligence would associate the goods of the appellant as that of the respondent. On one other significant factor which is lost sight of with the IAPAB board as well as the High Court is that the appellant is operating a restaurant under the trademark Nandini And it has applied the trademark in respect of goods like coffee, tea, cocoa, sugar, etc., meat, etc., which are used in the products and services of restaurant business. The aforesaid items do not belong to class 29 or 30. Likewise, stationery items used by the appellant in aid of its restaurant services are relatable to class 16. In these circumstances, there was hardly any question of confusion or deception.
Yes, Mr. They say that if it is a product of different classes,
Right.
and also, no, I understood that person who has believed that Purvankar, if he wants to buy that hardware, if he may thought that it is also belongs to your company, he can buy it.
Exactly.
But law is that if it is under a different class,
And I state even from this judgment body, judgment was there. The original judgment was purely on the question of fact. But you can please take the same compilation of the amendment senior here, page
yes,
and 62 paragraph number 26,
yes,
where there were 3 issues that the Supreme Court took note of
yes,
while deciding the mark should continue. Firstly, before I read paragraph 26, firstly, it was a case where the question of registration of a mark in the trademark registry was the issue before the court. It was not a suit for infringement or a suit for passing out as it is.
yes.
So therefore, factually, it could be a different scenario. That is a point which I'll argue.
Yes.
Because that's a matter. Secondly, but here is a case where please see page 62, paragraph 26.1. The respondent started using the trademark in respect of his products being sold with new products in the 1985.
Yes.
As against that, the appellant adopted the trademark in respect of its goods in the year 1989. Therefore, here, because the goods of both the parties, though belonging to an identical trademark, yours was almost used concurrently. But there is a provision under the Trademarks Act, section 12, where it specifically gives a right for a person who uses the trademark concurrently to get a mark registered.
Yes, registration is there.
Therefore, it is on that text that this entire judgment has to be read. Therefore, it is a case which morally went to the question of concurrent user because their users were 1985 and 1989.
Yes.
But in our case, my use documents which I have given date back to 1991 as far as the trademark Purva is concerned. Yes. Here we are not talking about the trademark Purvankara versus Purva. My company name is Purvankara. My trademark is Purva. A trademark remains Purva, yes, and I use it as a trademark.
Registered in 1981.
No, I'm using it since 1991. Yes. There are documents on record for that. Yes. They, in fact, started business in the year 2000 under the name Shiva Ferric High-Tech Private Limited. Yes. Only in the year 2010, yes, they even changed their name to Purva Metal Sections. Yes. So therefore, I would say even at the time of change of their trademark or their company name itself, there was absolute malafide on their part to have even changed it. But there is also a document which is on record, yes, where they filed a document to show that I should have known them. It was an invoice given by their erstwhile company named Shiva Ferric to the plaintiff company. So I had no occasion at that point of time in 2009 to know that they were using Purva at all. On the contrary, they should have known that I use Purva. So their adoption or the change in 2010 itself is malified. That was my case before the court, and that is something that the Interim judgment also considers. Will Lordship please take page 66, paragraph 34, which answers all these questions. Admittedly, the very first line, at page 66.
Yes.
Admittedly, for 10 years,
yes.
66.
Page 66.
Yes,
Para
34's continuation. I'm just reading from the half. I'm reading the first line. No, not in the judgment.
Oh, then
it is the input, not it is
in the appeal memo. In the appeal memo.
The appeal memo. Page 66. I'm so sorry.
Yes.
Page 66.
continuation of paragraph 34.
Yes.
Where the very first line, admittedly, my lord, has
Yes, yes.
admittedly for 10 years from the date of starting the business, the defendant has carried out business in the name of Shiva High-Tech Engineers Private Limited and not in their name of their surname. And the plaintiff has not used their surname for their business. The material on record also shows that the defendant is aware of the plaintiff's projects that is evident from the invoices produced by the defendant to the court at Exhibit D7 and D8. Hence, the defendant is aware of the trade name Purva of the plaintiff prior to changing the name of the defendant company. Under such circumstances, it cannot be claimed that the defendant is the bona fide user of the word mark Purva, and it's claimed that Purva is their surname and they are entitled to carry the name in the name of Purva. So this is the finding.
Yeah.
These are factual findings which they cannot be an answer at all. This is the kind of
No.
business.
All that, whether they are bona fide or not, only if it is similar, if it is effect to that other parties, court can be interfered. Whether with a mala fide intention he has started.
Yes.
But if it is not similar,
Yes.
it cannot be said that it is it can be contrary.
Absolutely. But in this
Now the
case,
question is that
yes,
whether it is a similar,
it is identical.
identical.
It is
It is an
identical. There is
identical.
no difficulty at all.
Now that what that Supreme Court said, if it is in the different class, you are doing in a business of construction.
I'll just read section 29(4).
Yes, for that you have to answer now. Now you have to answer to that question of the.
There is no difficulty at all. The Supreme Court judgment in 93 because is factually inapplicable to our case because there I will read both section
Is it for only in the question of registration or in respect of that?
I'll just show that to you. Section 12 you will lordship will see and section 29(4) also your lordship will see. Both operate in completely different spheres altogether.
I'm resubmitting. The principal consideration which your lordship would bear in mind is balance of convenience prima facie case. Not here is a case where my continuing my business and keeping accounts and furnishing the same to the honorable court will protect them ultimately. If they have not succeed, court will make an order against me. But in the interim, not to stop a running business.
He's saying that you should not apply one more application for similar name.
Trademark, my submission is trademark applications can be filed by anybody not if they have a right. But how can not a condition be put to me as a condition now that I should not file any application? If an application is filed, it's going to be contested and heard. As of now, my lord, I have no plans to file any application. That is what I'm submitting. But I don't want, my lord, that to be recorded for this reason, my lord, that today, if your lordships are thinking of the next 1 month or whatever it is, I'll advise them not to do any application.
Yes,
That may not.
My serious words, which I will take.
That is all they want. They don't want to make another application for 1 month.
No, they are apprehending that tomorrow you may file an application for construction also in the name of Purva.
There is, if I do, Lord.
Now that it is somewhat different class, now it will come to that same class. That is what that.
As of now, not the order that your lordships are pleased to pass will be relating to my business. Today, my business is this product. I don't have any construction business. And the name change which my learned friend referred to, that was an earlier fabrication company. This is another later company which is doing something different. So that
now that there is no. See, now I will grant limited interim order. We will fix the date. In the meantime, we'll.
Let them not make any fresh advertisements.
He has undertaken. No, he has undertaken. I am not passing an absolute interim order. It is for a limited period. Next time, if he filed any application, then we'll see that what that order is.
I'll bring it to you.
Yes. Day of order dated 15th November 2022, passed by 27th Additional City Civil Judge Bangalore in OS number 4974 of 2017. Next date of hearing, use this matter on 1st March. In the meantime, any required, we will call for records of office directed to secure original records. 1st March. Interim order is still 1st March. Number 44, government advocate. Yes.
Review petition, what is the?
Yes. Why you want to file an wakalat? I have not entertained that. Yes. It is a review petition. There is no any change in the Supreme Court judgments. Yes.
Yes, not. I see not that. Not in those judgments also. In fact, not in the different in the case of Chetilal Yadav.
Yes.
Honorable Supreme Court has consciously held that every case has to be dealt with on the facts of that case.
Yes. Now that on the basis of this, we have decided number of cases, even division bench has decided that has been affirmed by the Supreme Court.
Correct, Lord. But
Now you challenge. No, you need not go to the Delhi. You can here only you can challenge it.
Kindly see, Lord. No, I will just point out, Lord, how, Lord, even in that case, Lord, in this Chetilal Yadav and others case,
Yes.
there was a delay of 24 years.
Yes.
Lord, in filing an application for restoration. And after the application was filed, there was a delay of 16 years in the application was dismissed for default.
Yes.
And after 16 years, the application for restoration of that application was filed. Lord, irrespective of that, Lord, the Honorable Supreme Court will kindly turn to page internal para 11 of that judgment, Chetilal Yadav's case.
Yes.
In our view, where no period of limitation is prescribed, the action must be taken whether suo moto or on the application of the parties within a reasonable time. Undoubtedly, this would be not very important. Undoubtedly, what is reasonable time would depend on the circumstances of each case and the purpose of the statute.
Yes.
Not in this case, not coming back to the case on hand, not in the review petition. Not kindly see, Lord.
See, after considering this judgment,
yes,
Nikanti Rama Lakshmi's case, Supreme Court has decided. It is Supreme Court who has decided.
Yes.
See, if this is the case, there is no Supreme Court judgment, then we have to see clear actions that are depending upon the circumstances of each case and the purpose of the statutes. What is the purpose of this statutes, SC/ST Act?
Yes.
That has to be seen. But
Yes,
I can't look into now because Supreme Court has decided. See, that is true. Therefore, I said that it's even then you can seek for a review before the Supreme Court. The purpose of enactment is different. Here, if you see that object of that act is different to that object of that act, which is decided under that Chetilal case. Supreme Court has decided under that SC Act in that Nikanti Rama Lakshmi case.
Nikanti Rama Lakshmi. Lord, even in this case, Lord, under the same act, Lord, kindly see, Lord, the date of grant, Lord, it was a grant free of cost.
Yes.
The date of grant was 17/3/1981.
Yes.
With a non-alienation period of 15 years.
Yes.
Lord, date of sale is 6/4/1996.
Yes.
Lord, the application for restoration was filed in 2006 before the Assistant Commissioner, a little more than 9 years delay. Lord, your lordships have considered that.
Yeah.
Lord, when the application was filed, Lord, before the Assistant Commissioner, the respondent number 4 here, Lord, did not appear at all.
Yes.
Those served, Lord, he did not appear.
Yes.
Application was allowed on 21/12/2009.
Why that?
Yes.
In Supreme Court, in subsequent judgment, for 9 years also they said it is in a delay. I think I have not referred this.
Lord, there is one judgment your lordships have referred to, Lord. Lord, I will come to that also, Lord. Kindly see, Lord, permit me to just refer to the dates, Lord, what has happened in this case.
No. See, now that question is only delay. In this case, delay of 9 years to file an application.
Yes.
Whether it is in a reasonable delay or not. But Supreme Court in one case, for 9 years, they said that it is not a, therefore.
Lord, one aspect may be kindly considered.
Yes.
Lord, what is the subsequent events which have taken place?
Yes.
Lord, I do concede, Lord, that there was a delay of little more than 9 years.
Yes.
Lord, I filed an application before the Assistant Commissioner for restoration of the land. That was allowed on 21/12/2009. The aggrieved party, that is the respondent number 4, filed an appeal before the Deputy Commissioner on 3/8/2012.
I am sorry, my lord, immediately after
No.
that it was filed.
No,
It was
Mr.
dismissed on 3/8/2012.
No, all that is inconsistent. It is not this thing, because
Yes.
what the Supreme Court said, order passed by that assistant commissioner is without jurisdiction, because he has no jurisdiction after that limitation. Therefore, if he is challenging that order, there is a delay, there is no consequence at all. That is what the Supreme Court said, because power exercised by that authority after the delay is without jurisdiction.
Not
Then that order is nullity in law.
not when the Honorable Supreme Court not has held that it is without jurisdiction. The Honorable Supreme Court not has later observed that each case will have to be examined on the basis of the facts of that case. Not in this case, what happened? Not, after the Deputy Commissioner dismissed the appeal on 3/8/2012, date may be important.
Yes.
There was a delay of 8 months in filing the writ petition before this Honorable Court. Lord, the impugned order arises of the writ petition. Lord, the writ petition was filed on 6/4/2013. There was a delay of 8 months. It is an unreasonable delay, my lord. I would submit, Lord, that even this delay ought to have been considered. Lord, in between, my lord, between 3/8/2012 and 6/4/2013, within this 8 months period, the petitioner herein was put in possession of the property in December 2012.
That is, see, if you are put in the possession has to be taken back by due course of law. That is provided under that Land Revenue Act. That is what said in that SCST Act. We are not saying about possession. See, if that illegal order has been passed,
Yes.
of that order which has been passed without jurisdiction, just because challenging that in that delay in filing the writ petition, will not that say that the illegalities has been regularized?
Not, yes, my lord. If not, the party had approached this Honorable Court by filing a writ petition within a reasonable time, maybe 3 months or 4 months. Lord, that did not happen. When the appeal was dismissed on 3/8/2012, in December 2012, the authorities have put the grantee, original grantees LR, in physical possession of the property in accordance with law. That is not challenged at all. That was not pointed out before this Honorable Court.
No, that is what that, under that, there is a separate provision for taking the possession.
Please, my lord.
See, by declaring that sale is void, is not that automatically possession has go to that grantee.
No, my lord. That is the reason I pointed out.
No, that you are saying that
Yes.
after that order, they have taken the possession and given that possession.
Yes.
By giving the possession, order which passed without jurisdiction can be rectified. Can we say that it is be cured? No, it is always, void means it is void for all. Is it not?
No, if the facts of every case is considered, my lord. In this case, my lord, consequent to the order passed by the Deputy Commissioner, the petitioner in this review petition was put in possession of the property, and that could not have been, my lord, that was not challenged, that could not have been questioned by the petitioner.
No,
and
facts of each case has to be seen only for that approaching the delay. It is not that what is consequence.
Please, my lord.
No, because of
Yes.
this negligence or delay, the court said that order, the authority which has no power to exercise, can be said that it is legal.
When the order was passed, my lord, there was no subsequent. The Honorable Supreme Court judgment is a subsequent judgment.
No, all that is not an error apparent on the face of the record. It is on merit. You can challenge before the division.
The issue would be, my lord,
That may
the
be
Honorable Supreme Court, my lord, which says, my lord, the order of the Honorable, the Deputy Assistant Commissioner is without jurisdiction. While holding so also, the Honorable Supreme Court says you examine the facts of each case, and thereafter you hold that it is without
examine the
jurisdiction.
case only in respect of delay. See, if you have satisfied that delay for approaching, that can be examined. Then the delay can be controlled. Not that even though there is any delay, then because of his delay, your action taken by the assistant commissioner can be regularized. It is not that. Suppose you have explained the reason for approaching the delay. See, within 3 years he was not approached. You have approached after 9 years. Then you have explained the delay because of this I could not be approached. Then that case has to be looked into straight away because you have approached after 3 years. It cannot be. That is what that court said.
May I submit this, my lord?
Yes.
In the judgment, my lord, which I have sought to review, such a examination, my lord, of each case, my lord, has not been done. It be, my lord, the writ petition could be restored. Matter could be examined, my lord, with reference to the.
There is no error in that judgment. Yes, it is on merit you are arguing that the court has not examined that in terms of that. There is on merit that you can urge it in that the division bench.
That could be not
That is not an error apparent on the face of it. It is not error. It is an non-consideration of provision of law or legal this thing. It is a ground for filing an appeal.
It is the Honorable Supreme Court's observation, Lord. I would just point out, Lord, before my lord.
Yes.
And leave it at that, Lord. I cannot place.
No, because I am not sending you to the Delhi. Yes. Here only. Yes. It is not for difficult for but to approach. Yes. Third, learned counsel for the petitioner. He has submitted that. As per that, even the order passed by the Assistant Commissioner on 3/8/2012,
21/12/2009.
21/12/2009. The grantee has filed an appeal of lapse of
Yes, sir.
purchase. Yes, purchaser has.
That was dismissed on 3/8/2012.
No, is there any delay in filing an appeal? No, you are finding a fault with that purchaser's delay.
No,
Yes, yes, he contended that the appeal has been filed by the purchaser before the Assistant Commissioner. The appeal has been dismissed on
3/8/2012.
3/8/2012.
The petition was filed on after delay. Submission. Earlier, my lordship, my mandate not in the Wakala.
I don't know. Last time he has explained. Yes. There is a order has been Deputy Commissioner in the appeal has confirmed that order on 3/8/2012. The purchaser has filed a writ petition before this court after lapse of 8 months.
On 6/4/2013.
On 6/4/2013. Therefore, each case has to be considered.
Meantime, I was put in possession.
6/4/2013. In the meantime, the original grantee has been put into the position by the competent authority.
During December 2000.
During December 2012. Therefore, the purchaser is also in delay in approaching this court. This court has not considered this aspect of the matter. Each case has to be decided depending upon the circumstances of each case. Hence, he sought for review the order dated 18th February 2020. 2020. Yes, 2020. In the guise of reviewing the order, there cannot be a de novo hearing the case on merit. I have perused that order under review. There is no legal infirmity or error apparent on the face of the record. Hence, the review petition is dismissed.
ಅವತ್ತಿನ ಕಾಯ್ದೆ ಎಷ್ಟು ಲಕ್ಷದಿಂದ ಸರ್ 2 ಮಾರ್ಕ್ ಎಷ್ಟಾಗಿತ್ತು ಈ ಹೆಸರನ್ನ ಇದಕ್ಕೆ ತೋರಿಸ್ತಿದ್ದಾರೆ ಮ್ಯಾಟ್ರ್ ಗೌರ್ಮೆಂಟ್ ಅಡ್ವೊಕೇಟ್ ಹೆಸರು ಅಂತ
Item 45, Lord, I am for the,
Yes.
I am for the petitioner's counsel. Lord, this
Yes.
is a simple matter of renewal of a trademark. Lord, if you
Yes.
Lord could kindly see page 122 at annexure G.
So that you are an plaintiff. No, you have filed an application.
Lord, the trademark was originally granted in September 2005, and as per section 25 of the Trademarks Act, the validity is 10 years. Now, Lord,
Yes.
before the expiry, the trademark registrar is required to issue a notice. Lord, my grievance before your lordship is that he has not issued the notice. Would your lordship kindly
Yes.
have a look at section 25?
What?
This is the Trademarks Act 1999.
Yes.
Lord, if your lordship is having the professional's book, it is page 21, section
Yes.
25.
Yes.
If I read section 25, it says duration, renewal, removal, and restoration of registration, subsection 1. The registration
Yes.
of a trademark after the commencement of this act shall be for a period of 10 years, but may be renewed
Yes.
from time to time in accordance with the provisions of this section. 2. The registrar shall, on an application made by the registered proprietor of a trademark in the prescribed manner and within the prescribed period and subject to payment of the prescribed fee, renew the registration of the trademark for a period of 10 years from the date of expiration of the original registration or of the last renewal of registration, as the case may be, which date is in
Yes.
this section referred to as the expiration of the last registration. But subsection 3 is relevant for our purposes. At the prescribed
Yes.
time, before the expiration of the last registration of a trademark, not the words which follow next is important. The registrar shall send a notice in the prescribed manner to the registered proprietor of the date of expiration and the condition as to payment of fees and otherwise upon which a renewal of registration may be obtained, and if at the expiration of the time prescribed in that behalf, those conditions have not been complied with, the registrar may remove the trademark from the register. So what this implies is the statute.
It is obligation on him.
I have
It is
filed-
obligation on the authority to issue notice.
Yes,
It is
Lord,
not for.
the law imposes a burden on the officer to send me a
Yes.
notice imposing conditions depicting the fee to be paid, which he has not done. Lord, this can also be
Then
seen.
what?
Lord, now, my Lord, on the online, my Lord, page 123, if your lordship should
Yes.
see, I obtained a printout of the online. It says on the
Yes.
on top, my Lord, it says alert. Trademark is likely to be removed due to non-filing of renewal request within prescribed time. In case of any
Yes.
discrepancy, contact. Now, my Lord, as per the representation at page 124, I have made a request to the registrar to issue a notice to me. My Lord, he has not
Yes.
done it. My fear is, my Lord, he may proceed to remove my trademark from the.
No, by notice as per section page 123. This is a notice. You pay that renewal fee.
I'm willing to pay. He has to send a notice. He has to first send a notice, or lordship may direct me to pay the fee and.
No, that without notice you can't pay that renewal fee.
Entertaining. My Lord, he is not entertaining.
He is not entertaining.
No, he is not entertaining.
Yes. Now, what is that apprehension?
But my apprehension is that on page 123, my Lord, it is a status of my trademark. There is an alert which says it is likely to be removed. So therefore, my Lord, I am seeking interim relief. Let him not remove my name, my Lord. He has not issued notice to me. He has failed to discharge his statutory obligation.
Yes. Who is appearing for?
My Lord, this is a central
government. Yes. Till then, don't remove his name from this thing. Yes.
If not removed already.
Yes, yes. It is not yet removed. It is only alert they have given us.
Yes, sir.
Yeah. What's your name? So and so.
Kumar MN.
Is directed to take notice for respondent number 1 and 2. Respondents are directed not to remove the petitioner trademark under the application number 1241227 as annexure F if already not removed till next date of hearing.
I'm grateful, Judge. I'm grateful.
Yes.
I serve a copy on Mr. Kumar.
Learned counsel for the petitioner is directed to serve 2 sets of copies on your central government council.
We'll do that. I'm grateful.
Hearing matter, participants. For appellant, Vinay Vaiti.
Yes, what is this, Mr.?
Yeah. Appellants. Classes to be carried in the wagon.
Yes.
There was a excess quantity for which they have levied 1 lakh to the freight charges, which they sought for refunding. Then it takes to the found that it cannot be refunded. Their application for refund was rejected.
Yes.
That's the only question what they have argued with us. 1 lakh 50,000 amount towards excess freight loaded in the wagons.
Wagon.
That has been weighed and
Fine has been. Yes, so who is appearing for the other side?
after also it appears.
And we have to dismiss because it is an appeal. Can't decide ex parte. Or he allowed release this matter.
I think clearly recorded that the excess quantity was loaded.
No, but the point is, appeal cannot be decided. Either it has to be dismissed for default, or on the presence. I'll give one more chance. Yes. None appear. None appear for appellant. As a last chance, release this matter next week. Office is directed to delete the name of Abhinay Vaiti and Jagannath. Kumar Yemen appearing for the respondent has appeared. None appear for the appellant. As a last chance, release this matter next week. Otherwise, we will dismiss. 21. 14. Yes.
47, G. Vijay Kumar Swami for appellant, government advocate.
Mr. Yes.
Enhancement of the reference develop 44 and extent of but for the purpose of Yamavati channel.
Yes.
Land 51 coconut trees and 1 tamarind tree to open well and compose. The meager compensation awarded by the enhanced by the trial court. Whether they only 5,100 enhanced.
Now, what is that award passed by the land acquisition officer?
Land acquisition officer awarded only. Total 24,000 24,300 1 acre 14 guntas.
1 acre 14 guntas.
1 acre 14 guntas.
Reference court ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
Reference court 5,650 for gunta.
ಎಷ್ಟಾಯ್ತು?
Like 41,750.
No, that land acquisition officer has not granted any compensation in respect of that coconut trees.
Coconut trees and tamarind tree. More than 30 to 40 years.
Totally, he has awarded 24,300, 1 acre 14 gunta. See, climate number 21 is who is
climate number 19. Climate number 19 now.
19 and climate number 19 is entitled 1,41,000 towards the value of 1 acre. Value of that the land ಗೆ 1,41,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
1,45,000 coconut tree.
2,60,000 towards that value of 51 big coconut trees. 2,60,000 coconut trees ಕೊಟ್ಟಿದ್ದಾರಂತ್ರಿ. 5,000 towards the value of the one
tamarind tree. 30 years tamarind tree ಗೆ 5,000 bigger compensation.
ಎಲ್ಲಿ ಎಷ್ಟು ಕೊಡ್ಬೇಕಂತ ಏನಾರು ಇದೆಯಾ?
10,000 ನಾವು ಇದರಲ್ಲಿ value of the documents
ಏನ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏನ್ have you produced any document to show that? ಆಯ್ತ್ರಿ, ಯಾವ್ದಾದ್ರು ಒಂದು have you produced any documents that what should be that calculation?
ಅಂದಾಜು ಪರಿಹಾರ
ಆಯ್ತು, ಒಂದು 51 big coconut trees, ಒಂದು tamarind trees ಇದೆ, 5,000 ಕೊಟ್ಟಿದ್ದಾರೆ. ಇನ್ನು 5,000 ಅಂದ್ರೆ 5,000 ಜಾಸ್ತಿ ಆಗುತ್ತೆ ಅಷ್ಟೇ. ಇನ್ನೇನಿದೆ?
coconut trees ಮತ್ತೆ land 2,650 per ಗುಂಟಾಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ. 2000 ಅಲ್ಲಿ ಅವಾರ್ಡ್ ಪ್ರತಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಫೈನಾನ್ಸ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ 2,650 per ಗುಂಟಾಸ್. Then the salary is as per the exhibit before the trial court. 352 40 lakhs per acre.
Where is that finding?
The 50 exhibit 352.
What ಎಲ್ಲಿ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದಾರೆ?
ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ರೆ
ಕ್ಲೈಮೇಟ್ ನಂಬರ್ 19 ನೀವು
19 para number 18 32 minutes.
Where he has deposited the respondent acquired 1 acre 15 guntas 45 and
awarded the notice and exhibit 46 award
the value of 1 guntas 2 acres the value of 54
2,625 and the value of 1,41,750. The acquired land. The respondent removed 51 coconut trees 32 years old, 1 tamarind tree 30 years old, 1 stone well and the compose. Not
value can be fixed. There is already a fixed value. 1 coconut trees. Hey, 1 coconut trees as per that giant measurement report, 5,100 rupees. You show me that any documents are in any other cases coconut trees ಗೆ ಇಷ್ಟು ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ? ದೆನ್ ಅಲ್ರಿ, ಒಂದು ಕೋಕೋನಟ್ ಟ್ರೀಗೆ 5,100 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ, ಅಲ್ಲಂದ್ರೆ 889. That has been enhanced to 5,000. Yes. If you give me any document to show that for a coconut trees in any other cases it is granted more than 5,100 rupees. ಏನದು?
ಇಳುವರಿ ಪತ್ರ.
ಆಯ್ತ್ರಿ, ಇಳುವರಿ ಪತ್ರ ಸರಿ ರೀ.
ಅದರಲ್ಲಿ ವರ್ಷಕ್ಕೆ how much the growth yield the coconut is
Climate has produced the award notice. Award program confirming that climate number 5 is the data holder of the said survey number. Hence, as the held above, the value of the 1 gunta of land is fixed.
47 million.
The value of the 39 guntas will be fixed.
Airport is not awarded, is not considered the open well under composement.
Award proceedings confirm that climate number 5 is the data holder of the said survey number. Hence, he has held above that value of the 1 guntas of land is fixed. That value of the 39 guntas of the land is fixed.
As per the exhibit 353 million, the proceedings of the award notice were
that in the acquired land, respondent removed 48 coconut trees, and whereas the award proceeding GMC report confirmed that trees are value of the 48, so the climate number 610. So that 5 guntas of the land 48. Where is the discussion regarding that land? 1 guntas of the land is fixed 2 lakhs. Thus the 39 guntas of the land is 1,02,000.
Consolidately, they have taken 2,006 from the. So it's not specifically. It's not given there.
New climate number 19.
19.
Climate number 19 ಗೆ entitled for an compensation of rupees 1,41,000.
Towards the land. 2,60,100 towards the value of the 51 Concurrent. 5,100 each. Camel entry. It's not any awarded in the open well and post. As per this participation in the award proceeding itself. Now mentioned
1,41,000 ಹೆಂಗ್ ಮಾಡಿದಾರ್ರಿ?
2,625 per guntas ತಗೊಂಡಿದ್ದಾರೆ. ಒಂದು ಗುಂಟೆಗೆ 2,625.
ಏನಿದೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್?
ನಾವು ಡಾಕ್ಯುಮೆಂಟ್ 1,40,000.
ಏನು what is the documents you have given, Mr.
Have taken so
No, you have to prove that.
Now produce the
What is the document says?
Said it.
That is there is a report saying that there is no well. See, what is the basis of? You verify under the records. That our model NCR ಅಲ್ಲಿ is there any records they have produced to show that land of this? Yes. At the request of the parties, use this matter of 2 weeks. Yes. Yes, Mr. There is that other side. Allah, idu yeno still that suit is pending.
ಇಲ್ಲ ಸರ್ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. appeal has been filed against the dismissal of miscellaneous petition.
For recalling that this thing. Then they are not interested. Why to why? Yes. None appear for that appellant. Read this matter of 2 weeks. Finally, yes. Finally. Yes, Mr.
This is case of death, my lord. This case, the claim petition, if to be dismissed by the criminal only from that certificate has not been recorded a body. Witness is there, my lord. The question is tab number 11 of the judgment, which is page number 10.
Yes. Read.
And arguments since I find that applicant has herself got examined the cross-section and he has yet to be one variant. She stated that she is not an eyewitness. Actually, she does not know anything about the incident. Moreover, AW1 her evidence since chief by has stated that her husband went to meet his relatives and would be returning on the same day night, whereas during the cross-examination, she deposed that her deceased husband was together to attend the family function and on the same day evening. She also stated that one Raju, friend of the deceased husband, accompanied deceased to railway station to seeing up, but she do not aware whether the police have recorded this said Raju statement. To mention that the applicant has they said Raju as evidence to prove the case. Though inquest report informs that deceased fell down from the train, sustained the injury and died. There is no corroborate evidence for the same. While in the police report, nowhere IO has stated that the deceased has fallen down from the train, but merely concluded that the death of the deceased is accidental. Only that ground, criminal dismissal the claim.
As such, all these facts and circumstances need to inform that deceased was not bona fide passenger. And yes, what are the materials you are relying that death is due to fall from the train?
Statement, DRM report, which is prepared and submitted by the respondent authority.
What is the DMR report? As the court has not considered that.
DRM report is simply saying that this is not
No, that your evidence is not supported by any other evidence.
My evidence clearly corroborated with the incident of what the statement. has been
Now that
given
we
by
see
the
that
parties at the
DMR
end of the
report.
incident. Sorry, in this case, journey ticket is recovered.
Journey ticket is recovered. If you're taking that journey ticket and you dead somewhere else, it is not any criteria. Really, journey ticket recovery ಆಗಿದೆಯಾ?
Journey ticket recovery. DRM report conclusion from the above inquiry is.
Where is that? Which is that DMR report?
DRM report. Exhibit R1. Except that document, no evidence has been case of the applicant.
Yes, connections with the above statutory inquiry report, DMC has three facts that reported to that one led by body later identified was found lying at inquiry with that Sangeeta deceased wife divorced that number day. Conclusion from the inquiry it is established that deceased person was not a bona fide passenger. There is no evidence available to suggest that he had fallen from the train. Ian report is also said that not fallen traveling in the train.
Without assigning any reason, Miller. They cannot say like that, Miller. Because no evidence has been adduced by the respondent to rebut the case of the applicant.
No, first they are saying that whether you have proved.
Yes, Miller. Once I have submitted several judgment in previous occasion, Miller. Once the contentions taken by the parties by way of affidavit, it is held by in Rinadevi judgment also. Burden of proof always lies on the respondent to rebut the case of the applicant because it is a social welfare legislature policy, Miller.
They have not examined any witness.
AWR Miller and DRM report, Miller. In DRM report,
No, they have not examined any.
For examining any person, Miller. In cross examination of the AWR, nothing is elicited, Miller, to rebut the case of the.
No, that what you want to say that the ARM report. You said
that is my contention without saying any reason.
No, that they have not.
This is not a case of.
They have not examined any witness.
Nothing, Miller.
What is that?
In final report, which is part and parcel of the DRM report, kindly see the final report. Detailed police report is final report is there, Miller.
Where is that?
The DRM report, Miller.
Yes. What is that charge sheet?
There is final report.
Where is that charge sheet?
Detailed report is there, Miller.
Actually, ಏನ್ report ಹಾಕಿದ್ದಾರೆ ಹೇಳ್ರಿ. Hospital, what is that?
I am of opinion as to cause of death is due to shock as a result of sustained injury by moving train ಅಂತ ಸೂಚಿಸಿರುತ್ತಾರೆ. This is final report, Miller.
ಎಲ್ಲಿದ್ದಾರೆ? ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
DRM report ಆದ ತಕ್ಷಣ ಇದೆ. ಅವರೇ ಹಾಕಿದ್ದಾರೆ. DRM report ಆದ್ಮೇಲೆ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ.
Railway conclusion from the above inquiry, it is come to the conclusion that it is a false case since such an incident will happen, train will suffer detention number so and so, is here to see. There is no any fault on the part of the railway administration. Hence, cause is closed. Then this is final report. Final report ಅಲ್ಲಿ ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
report ಅಲ್ಲಿ next ಕಾಲಂ ನಂಬರ್ 17ಕ್ಕೆ ಪ್ರತ್ಯೇಕ ಹಾಳೆಯನ್ನು ಲಗತ್ತಿಸಿದೆ ಅಂತ ಹೇಳಿ ಸೆಪರೇಟ್ ಹಾಳೆ ಕ್ಲೋಸ್ ಆಗಿದೆ.
ಅದು 29 ಪೇಜ್. ದಿನಾಂಕ ಮುಂಚೆ ಠಾಣೆಯಲ್ಲಿ ವಿತರಿತ ಸೋನ್ಸೋ ಕನ್ಕ್ಲೂಷನ್ ಎಲ್ಲಿದೆ?
ಲಾಸ್ಟ್ ಮೃತನ ಮರಣದ ಬಗ್ಗೆ ಮಾನ್ಯ ವೈದ್ಯಾಧಿಕಾರಿಗಳು ತಮ್ಮ ಅಭಿಪ್ರಾಯವನ್ನು ಈ ರೀತಿಯಾಗಿ ಸೂಚಿಸಿರುತ್ತಾರೆ. ಐ ಆಮ್ ಆಫ್ ಒಪಿನಿಯನ್ ಎಸ್ ಟು ಕಾಸ್ ಆಫ್ ಡೆತ್ ಇಸ್ ಡ್ಯೂ ಟು ಇಂಜುರೀಸ್ ಬೈ ಮೂವಿಂಗ್ ಟ್ರೈನ್ ಸೂಚಿಸಿರುತ್ತಾರೆ. ಸದರಿ ಪ್ರಕರಣದಲ್ಲಿ ಮೃತನ ಸ್ಥಳದ ಸನ್ನಿವೇಶ ಸ್ಥಿತಿಗತಿ ವಿದ್ಯಮಾನ ಮತ್ತು ರಕ್ತ ಸಂಬಂಧಿಕರ ಹಿಡಿತ ಬೆರಳು ಪಂಚರ ಅಭಿಪ್ರಾಯವನ್ನು ಅವಲೋಕಿಸಲಾಗಿ ಮೃತನ ಸಾವು ಆಕಸ್ಮಿಕ ಸಾವು ಎಂದು ಪರಿಗಣಿಸಿ ಮಾನ್ಯ DSRP ಸಾಹೇಬರು
ಹುಬ್ಬಳ್ಳಿಯಲ್ಲಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ 13ನೇ ಸಲ್ಲಿಸಲು ಅನುಮತಿಗಾಗಿ ವಿನಂತಿಸಿಕೊಂಡಿದ್ದು ಇರುತ್ತದೆ. ಇದರಲ್ಲಿ ಪಂಚನಾಮೆ final report produced by the respondent police upon the statement of Panchas. Panchas statement is clearly stated that deceased death of the deceased occurred only fallen from crime.
Yes, what is that judgment you are considering?
There is judgment only this. Once the contents is taken by the applicant by filing burden of proof lies on the recipient to the respondent.
Yes, heard. This appeal is filed by appeal is filed under section 23 of Railways Claim Tribunal Act, challenging order dated 20th February 2016, passed by Railways Claim Tribunal in OA number 42 of 2012, whereby application filed by the applicant is dismissed. For the convenience, parties to refer their ranking occupied as per occupied before the tribunal. The case of the applicant that on 11/12/2011, what is the name of the deceased?
Tukaram
Deceased
Gadapanavar.
Tukaram Gadapanavar was traveling. Gadapanavar went to Gadag from Hubli by train to see his relative. As such, while he was returning on the night train, accidentally he fell down from the moving train, sustained injury. And he succumbed to that injury. The applicants are wife and children.
Yes,
Wife and children have filed that application.
and mother, children and mother.
Wife, children, and mother of the deceased has filed an application under section 16 of City Act before the Railway Tribunal on application 42 of 2012. First applicant, the wife of the deceased, has been examined as PW1. How many documents you have produced?
10 documents. Exhibit A1 to A10.
And they have produced 10 documents. Respondent has not examined any witnesses. Have they produced any documents?
Except DRM report, nothing is produced.
They have produced
DRM
report.
DRM report.
DRM report. They have not examined any witnesses. On the basis of the oral and documentary evidence of the parties, the Railway Tribunal has dismissed the application. Being agreed by the same, the applicant has filed this appeal before this court. So and so learned counsel appearing for the applicant has contended that the wife of the deceased has been examined as PW1. She has categorically stated that when deceased was deceased was fell down from the train and suffered injury and he succumbed to that injury. And the police has registered an FIR after thorough investigation has filed a charge sheet. The deceased was died as sustained injury, fell down from moving train and succumbed to that injury. Therefore, the claimant has discharged their burden by filing by examining AW1 and producing the documents. The burden is shifted on the railway authorities to disprove the case of the applicant, except producing DRM report. They have not examined any witnesses. They have not discharged their burden. In support of his contention, he has relied on judgment of Apex Court in case of Reena Devi. Hence, he sought for allowing that appeal. For contra, none appear for the respondent. Heard the learned counsel for the appellant. The case of the appellant that on 11/12/2011, deceased Tukaram Gadapanavar returning from Gadag in a train. Which is the train, Mr.? Yeah,
train is not mentioned.
Returning from the train, he fell down from moving train and sustained injury and succumbed to that injury. To prove the case, the first claimant has been examined as PW1 and they have produced 10 documents. On the basis of the complaint lodged by the applicant, the police is also registered an FIR and filed an
Case registered by the station master.
Yes, under the complaint of applicant. The police is also registered an FIR. After thorough investigation has filed a charge sheet. Also, it is mentioned that there is an opinion of the doctor that cause is due to the shock as a result of sustained injuries by moving train. By examining PW1 and producing that documents, the applicant has discharged their burden. Now, onus is shifted on the railway authorities. The tribunal is error in held that the applicant has failed to discharge their burden. The Apex Court in case of Reena Devi Supra, paragraph 25 and 26 extract. In view of that above judgment, I am of the opinion that the finding given by the trial court is contrary to the provisions of law. Hence, the appeal has to be allowed by set aside the judgment and award. Accordingly, The appeal is allowed. Order dated 28th April 2016, passed in OA number 42 of 2012 is set aside. The matter is remitted back to the Railway Claims Tribunal to reconsider that matter afresh after giving an upper to both the parties. Make clear that the tribunal has to decide that matter in accordance with law without influencing any observation made by this. Tribunal is directed to decide the matter in accordance with law. Any observation, but I can think we have given the finding. Okay. Yes, Mr. But what is this? What is that matter?
Injection. Injection.
Temporary injunction.
Yes.
Now, what is the stage of the suit? Huh? Now that you have any interim order before this court?
No.
You have no interim order from the date of 2017 till today. Let that suit may be disposed of. In that terms, I can dispose of.
There are certain legal issues involved only for that.
No, that legal issues, you are not deciding on that suit. It is only for that injunction. I will direct them to decide the suit without influencing any observation made in this order.
Really?
Can I grant any injunction after 5 years? Temporary injunction which is not there in your favor.
It will only be for dismissal. As a sale agreement in favor of the respondent was executed by my vendor.
Yes.
And file a suit for specific performance. In the meantime, sale deed was executed in my registered sale deed was executed.
Yes.
And because of the interference, file a suit for injunction. And the defense of the defendant is that along with the sale agreement, possession was given to them.
Possession is spotted. Is that sale deed the agreement? No. Agreement. Is there any possession has been parted with?
Yes, it is strictly that possession has been handed over for that sale agreement.
Then they have been in the possession before execution of the sale deed.
No, not that cannot be recognized. This my submission because under Registration Act, when they or under Section 53A,
it is not deciding the title.
Not the title. Even for possession also to claim the possession through an agreement of sale, it is a mandatory requirement that sale agreement should be registered. That it's not a registered sale agreement.
Can the court going to that regarding all that?
Yes, we know.
That is anyhow that on merit. Now that we don't have any injunction ad interim order for last 5 years, I will direct the suit will dispose of early. Yes, what is the stage in the suit?
I have no idea about that.
His means he is a defendant. Then yours is also, now it is only for the argument. No, I'm not deciding on that all that.
He was one of the witnesses for the sale agreement.
Even
He
for
was one
that,
of the witnesses.
I will not put that back.
No, I will not go all these points. Therefore, I will not allow.
My focus will my discourse of my contention, legal contention is that they claim the possession based on the sale agreement, which is not a registered agreement. And to get a protection under Section 53A of the transferred property is a mandatory requirement.
That let that civil court decide on that issue when that suit has to be decided. Yes, this appeal is filed by the plaintiff challenging order dated 26/7/2017, passed on IA number 3, IA number 2 and 3, filed under order 39(1) and 2, whereby application for temporary injunction has been rejected before this court. Very good.
10/4/2019. New manual.
Adidre, that will be continue. That's what I am asking.
10/4/19 order sheet.
10/4.
Then for 19.
No, both the parties are directed to maintain status quo. That is there. I will say that.
No, it is already there.
No. You take that benefit. Status quo, yes. Yes. Plaintiff has filed a suit. The parties are referred to their ranking as per the trial court. Plaintiff has filed a suit for injunction. Along with that, plaintiff, he has filed an application under 39(1) and 2 for restraining the defendant from his agent to interfere into the suit scheduled property. On appearance of the defendant, they have filed then a written statement and also filed an objection. After consideration of the arguments of both the parties, trial court has dismissed that application by impugn order. Being agreed by the same, the plaintiff is before this court. This court, by order dated 14/10/2019, has directed the parties to maintain status quo. Now the suit is set down for evidence. Under these circumstances, the only relief can be granted in this case is that parties may be directed to maintain status quo till the disposal of the suit. Accordingly, the appeal is disposed of. Order dated so and so is modified to that effect that parties are directed to maintain status quo in respect of suit scheduled property till the disposal of the suit. Yes. It is also made clear that the trial court has to decide that suit in accordance with law without influencing any observation made in that impugn order. Court, no, see, case has to be decided finally on the merit. They can't rely on that whatever finding given by that. No, that's I will make it clear. Yes, not without. Yes, without decide that case on merit, without relying on that observation made in that.
Yes, observation.
I'm bad. Yes, yes. Let them.
Order 10/4/19.
10/4/19. Yes. If you are there for that, you go. See.
Again, it goes to the root question, my lord, that in the absence of registered sale agreement.
Final.
With my learned friend is again and again insist that I am in question. That legally such question, if at all, if there is, they cannot be recognized.
No. That is for that finally suit will be decided. Then injunction will be granted to you.
Yes.
But even then, even unauthorized occupants, you cannot be.
Unauthorized occupant. See, the claim, of course, legally, I am not.
Yes, no, that is
legally, law requires.
No, but true. Ultimately, court said that defendant is illegal possession, but court cannot throw.
No, it's not like that.
But tomorrow, court held that yes, seizing the possession, but the possession is not legal. Can the court say that you remove in that suit for injunction? It cannot be.
My interpretation is like this: on a sale agreement, they claim the possession, and whether such a possession can be recognized under section 53.
No, that is true.
The difference is that
even if it is not recognized,
yes,
if he held that she is in the possession, can be thrown out in the suit for injunction. That is the case.
No, I will consider it's
when your case should be suit for possession also.
It's a declarative suit.
No, is it suit for declaration?
Yeah.
No, only injunction.
Because.
No. Wait, not for that. I have dictated only
Declaration.
suit for declaration.
Declaration.
Yes.
Next matter 51.
Hmm.
In connected with MFA 1981 members.
Call this matter along with that MFA so and so. Yes. Hmm. After 2 weeks at the request of the parties. Yes, next week. Yes. What about 54? 55? Yes, next week. ಅಲ್ಲಿಗೆ ಅದೊಂದೇ ಉಳಿಯೋದನ?
ಇದೆಲ್ಲ ರಾಜ್ಯ ಹೋದ್ರೆ ತಗೊಂಡೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್, ನಿಮ್ ಟೇಬಲ್ ಅಲ್ಲಿ ಇಟ್ಟಿರಿ ಅದನ್ನ. ಗಿರೀಶ್ ತಗೊಂಡೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇನ್ನೇನು ಮುಂದೇನ್ ಮಾಡ್ತಿದ್ದಾರೆ?
ಕೊಟ್ಕೊಂಡ್ರೆ ವೈರಿಲ್ಲ ಸಾಹೇಬ್ಗಳನ್ನ
ಟೂನಲ್ಲಿ ಅಡ್ವಾಂಟೇಜ್ ಬರ್ತದಲ್ಲ ಬರಬಾರ್ದು ಅಂತ
ಅವನೇನು ಸ್ಟ್ರೈಟಿಂಗ್ ಕೊಟ್ಬಿಡ್ತಾನೆ ಕೊಂಡಾಯ್ತಾನ ಆಮೇಲೆ
ನಾವು 28
ಈಗ ಬಿಚ್ಚಬೇಕಾ ಹೇಳ್ಬಿಡಿ.
ಹಾ ನಾಳೆಗೆ ಒಂದ್ ಇದೆಯಲ್ಲ ಎಲ್ಲಾರು ನನ್ನ ಹತ್ರ ಆಯ್ತಾ ಹ್ಮ್ ಎಷ್ಟು 4 2 3 3ನೇ ತಾರೀಕಲ್ವಾ ನೋಡ್ತೀನಿ First of matter, case number 1, serial number 7, appellant, that
So you are appearing first,
Appellant.
and you have to commence that argument.
Oh, last occasion, not just to recall, matter was argued for some time, but I'll just point out quickly again.
Yes. So he's coming.
Allow, he's coming, this on.
What to do?
I told my lord the court, the rest
Yeah,
of it is completed.
Yes, because of this case only I have adjourned on the matter. Just suit for.
Lord, suit is filed for alleged violation of a trademark. Lord, let me perhaps, if you watch this permission, just start with the facts and then we'll
Yes,
reset. Because I don't know, we make the court also wait. Lord, suit is filed. Lord, please take the plate for a minute.
Yes.
Plate begins at page 95, Lord, of the field compilation.
Yes.
Plaintiff, who's the respondent before your Lord.
Yes.
95.
Yes.
Plaintiff is a company.
Yes.
So is the respondent. Our respondent is the appellant before your lordship.
Yes.
Now, Lord, the plaintiff is in 2-3 businesses.
No, you are in a defendant.
I am the defendant. The defendant's appeal. Injunction has been
It is
granted.
mentioned that petitioner, therefore it is confirmed.
Sorry,
Yes, defendant appellant.
although there was a previous writ petition, this
Yes,
is the
yes,
problem of
yes,
Lord, computer copy
Yes, yes.
pasting. Now, ಮೊದಲು type ಮಾಡಬೇಕಾದ್ರೆ this problem would not occur.
Cut and paste is
Cut and
that,
paste is.
what is that prior?
Lord, please come to the prayer begins at page 112. An order and decree of perpetual permanent injunction restraining defendants, its affiliated companies, representatives, employees, servants, etc. from carrying on business of manufacturing, selling, marketing, advertising, offering for sale, importing, exporting, etc. goods and services under the marks, names, labels. Pigeon, your lordship should see that there are 3 marks mentioned.
Yeah.
Pigeon within words. Pigeon Industries Private Limited, that is the name of the company. And Pigeon India, that is my website. Or with other deceptively similar mark or name of business concern, name, get-up, which are both visually and politically deceptive, similar to, or in any manner whatsoever amounting to infringement of the plaintiff's registered trademark, Pigeon word and Pigeon device mark. Now, please notice that in the about 6 lines above the last logo which is there, that logo and this logo are quite different. The registered mark is the one in the last line of the prayer. What they ask for prayer, the injunction is in the middle of that prayer. Then second prayer, my lord, is a similar one in relation to passing on. The first prayer is relating to infringement.
Yes.
But your lordships are fully aware, infringement is in a registered trademark, passing off is in unregistered. Then C is to render accounts for the profits that may have been made by using of these marks.
Yes.
Prayer D over the page is to change the corporate name and remove the plaintiff's word mark Pigeon from its corporate name. That is the name of the company. I have to change my name is what they say.
Yes.
He is to take down the website. Mandate injunction. I have to change my